Good afternoon, everyone. The Appellate Division First Department is now in session. As a first order of business, I will be calling the calendar. Please listen for the case to be called, and when you hear your case, please respond by identifying yourself by name and who you represent. People versus Panada, submitted. U.S. Bank National versus Karuna, submitted. Nanan versus Stephen L.
Good afternoon, Your Honor. Renee Kapawala for the appellate, Ms. Liu.
And Jason, advocate for the respondent, Stephen L. Thank you.
All right, the time allotted for your argument is 4 and 2 for the appellant and 4 for the respondent. The next two cases are called together: Zymer versus the City of New York and the City of New York versus Zymer.
Good afternoon, Your Honor. Jordan Harlow for the appellant, Nadav Zimmer.
Good afternoon, Your Honor. Jonathan Popolo for respondent, Department of Education.
Right, these cases are being argued together, and the appellant is allotted 6 minutes and 2 for rebuttal. The respondent is allotted 2 minutes. Tarjavara versus Considine. It's submitted. People versus Jose Feliciano.
Claudia Troop on behalf of Jose Feliciano. Good afternoon, Your Honor.
Rafael Curbelo for respondent. Good afternoon, Your Honor.
Good afternoon. The appellant is allotted 7 and 2, and the respondent is allotted 5 minutes on argument. Preserve Our Brooklyn versus the City of New York.
Good afternoon, Your Honor. This is Eric Lee for the city respondents.
Good afternoon, Your Honor. This is Richard Lobel for respondents, South Portland and Randolph-Hague Daycare Center.
All right, we have no appellant arguing here today, so the appellant's case will be marked submitted. Each of the respondents is separately given 3 minutes to argue.
Thank you.
Cologne versus 385 Fifth Avenue is submitted. Rank versus Rank.
Good afternoon, Your Honor. Fred Bronstein for appellants.
Good afternoon, Your Honor. Rafael Vergara on behalf of respondent.
Right, the appellant is given 4 and 2 minutes for rebuttal, and the respondent is given 4 minutes in this case. People versus Suazo is submitted. Panettone Development versus Scout Fund.
Good afternoon, Your Honor. Joseph Perry for appellant, Scout Fund. I'm here to introduce my colleague, David Janender, who will ask permission for the court to argue pro hoc vice.
Okay. Do we have a respondent?
Yes, Your Honor. Charles Cummings for the respondent, and with me today is Daniel O'Connor of the Illinois Bar, who will be arguing the appeal pro hoc vice with the permission of the court.
Right, with my permission. What we'll do, first of all, let me just indicate that we're allotting the appellant 8 minutes and 3 minutes for rebuttal, and the respondent 3 minutes. I will hear the pro hoc vice when I call the case. HS Bank versus Santiago. I have a notation that that's going to be withdrawn. And I'm going to mark it withdrawn. Sandy versus Trinity Center.
James Baker for the appellants, Your Honor. Good afternoon.
Good afternoon.
Good afternoon. Evie Kazansky for the respondents.
Okay. And the time allotted for your argument is 5 and 2 for the appellant, 5 for the respondent.
Thank you.
Thank you, Your Honor.
Thank you. R&B Children, that's marked submitted. Roa versus the City of New York.
Chris Sabro on behalf of the appellant.
Good afternoon, Your Honor. Stephen Brewy of counsel to Nadine Revelisi for respondent Con Edison.
Leslie Siskind on behalf of Abner Properties.
We have 5 and 2 for the appellant. Con Edison, you have 5 minutes, and the Abner Properties, you have 3 minutes for argument.
Thank you, Your Honor.
Thank you, Your Honor.
Fuller versus KFG Land.
Good afternoon, Your Honor. Seth Weinberg for KFG.
Good afternoon, Your Honor. George Ilkert for the respondent, cross appellant Fuller.
Right. We have an appeal and a cross appeal, so the time allotted is 5 and 2 for the appellant and 5 and 2 for the respondent cross appellant.
Thank you, Your Honor.
McFall versus the City of New York is submitted. Zamir versus Ben Harosh is submitted. 801 to 803 versus 805 9th Avenue is submitted. And State of New York versus David S.
Good afternoon, Alexandra Keeling for David S. Appellant.
Good afternoon, Your Honor. Mark Grube for the State of New York, respondent.
And the time allotted for your argument is 8 and 2 for the appellant and 8 for the respondent. Thank you. All right, we're going to call the first case, which is Nanan versus Stephen L.
Good afternoon. May it please the court, Renee Kathawala from Ora Carrington Sutcliffe for the appellant, Ms. Liu. This appeal presents a simple issue about a critical failure in a straightforward child support violation case that incredibly lasted nearly 7 years. In our briefing, we've detailed how the family court judge made 3 clear legal errors. However, if you agree with Ms. Liu on the first issue we've identified, we believe it requires this court to remand this matter back to the family court for compliance with Family Court Act Section 439A. Indeed, respondent did not oppose this aspect of Ms. Liu's appeal in their opposition brief. Plainly, the family court judge failed, consistent with Family Court Act Section 439A, to confirm the recommended purge amount and the willfulness finding itself. New York Family Court Act Section...
So here's my question to you. So, you know, clearly, after the support magistrate made the contempt finding, all parties seem to understand that it then had to go to a family court judge to be confirmed. Otherwise, it didn't have effect, correct?
The parties understood that that's correct.
All right, so it went to a family court judge, and by that time, the respondent had paid the purge amount. So the family court judge apparently took no action in confirmation, or could it be seen that he implicitly confirmed? What happened at that?
Yeah. Your Honor, that is the heart of this. This is the heart of the appeal, and I would direct the court to the relevant pages of the transcript. If you read, it's a very short transcript. It's, I think, 11 pages. The family court judge said, and this is important, he said, quote, on page 5, it's line 18 to 20, there is no this is a quote, there's no reason in the world why this should be here if indeed you have proof of the payment. So the family court judge was only interested to learn whether the respondent paid the purge amount, the $84,000 in purge that was recommended. He didn't, for some reason, understand his obligation under the Family Court Act to both either confirm, deny, or hold a de novo hearing on the question of willfulness, and then what the purge amount should be. In fact, my co-counsel in the case at page 8 made the very argument we're raising here in the appeal, that we wanted the judge to increase the purge amount because effectively the purge amount resulted in the child support order, which was over $8,000 per month, to be reduced to $750 per month. The judge basically said, I'm not hearing that. I do not have proof. The reason the judge sent it back was he didn't have actual proof that the purge amount had been paid. And that was his sole issue that he was focused on at this confirmation hearing. And I think the quote from page 5 of the transcripts is proof positive that the family court judge abdicated his responsibility to discharge his obligation under 439A of the family court. And that's really the heart of this issue. We challenged in our objections the purge amount. The family court judge on page 13 of her decision on the respective parties' objections said the appeal is not properly before the family court because the proper mechanism was for Ms. Liu to appeal the purge amount if we were unhappy with it. We couldn't appeal the purge amount because it was never confirmed. So what we're saying here today is that the matter has to be remanded so Judge Richardson can make a determination as to whether to confirm the purge amount, whether to confirm the willfulness determination, which the latter we submit is absolutely required. And we believe that based on the evidence, the record evidence, this is a respondent who gets $20,000 per month in support from his father, who happens to be a billionaire, and that an $84,000 purge is woefully deficient. But unfortunately, we're going to have to go back down to the family court in our view, have the judge follow 439A, determine whether to accept the purge or not, determine whether to accept the willfulness finding, and then potentially come back here, depending on what the court does with the purge amount. Unfortunately, it's an inefficient process, but it's one that is necessitated by what happened below.
All right. You've a lot. Your allotted time is done. So whatever else you need to say, you'll have time in rebuttal. Okay.
Thank you, Your Honor.
Let's hear from your adversary.
Good morning, Your Honor. May it please the court, I'd like to respond briefly to Mr. Cathwala's remarks. What he said to the court a few minutes ago was that with respect to the transcript, and I believe he was citing the December 16th, 2019 transcript of a proceeding before Judge Richardson, the family court judge down below, and he was referring to page 5 of that transcript. Well, he said the sole issue that day was whether the amount had been paid. That really was not fully accurate because, in fact, Judge Richardson asked directly about how the purge amount was obtained and how they got to that number. And he said specifically that that was something that he asked about. Actually, he asked about it twice. And in response,
Mr. Advocate, this is Judge Gasner. It is correct, though, that Judge Richardson didn't actually confirm or disaffirm Judge Richardson's, the support magistrate's purge amount or the recommendation as to incarceration and willfulness, correct?
Correct. And I think it's basically an implicit acknowledgement, but you are correct.
Okay, but counsel said that you basically didn't dispute that this has to go back to the family court for further findings with regard to the support magistrate's hearing. Is that correct, that you don't dispute?
No, I do dispute the fact that it has to be sent back down. I do not think it does. I think it's an implicit, and it's very implicit in what occurred here in two respects. In one respect, at the Richardson hearing, it was addressed, the issue of the purge amount. And in fact, Mr. Cathwala directly said, in fact, that we are actually wanted to raise the issue of the purge amount. We raised the issue of the purge amount of $84,000 with Magistrate Mahoney, and he directed us to address this with you. That's page 8. And then Mr. Cathwala goes on to address the issue of the purge amount and why he believed that amount was too low.
Go ahead. Was there anything that Judge Clark did on that day that was appealable? Was there an appealable order, a piece of paper, something from which if somebody disagreed with what the judge did, it could be brought to us and we could review the merits of whether the purge amount was correctly set and or the remedy correctly set? And I believe there was a collateral issue of whether a payment schedule should have been ordered. Because there was a lot of arrears. There were judgments.
Yes, there's a judgment for, more than $800,000 in this case. Was there anything to appeal from in that order? I don't believe so. But there was a subsequent order which was appealable. That's where they filed their objections to the purge amount. They filed their objections. It got heard by Judge Pels, and Judge Pels declined to change the purge amount. So you have both
She didn't really do that. She said that it had already been determined. So can we reach the substantive arguments by on Judge Pell's determination?
Well, she let stand the lower court's determination, not the lower courts, I should say the magistrate's findings. So again, both Judge Richardson and Judge Pels are letting stand the magistrate's findings of what the appropriate number for the purge amount was. So I think
she let them stand by not reaching them.
Well, I don't know if they necessarily did anything more than say, we believe the lower court or the magistrate was correct in its number, and then said, we're not going to change that number, even though Mr. Cathwalla argued the point on the December 16th, and they argued it again in the objections. It's been raised and argued twice.
Though there's never been any determination by any court so holding, though, right, that we are not going to change the purge amount. No family court judge has ever held that, have they? That we are not going to change the purge amount? They
have not said those exact words.
So how could that be an appealable order then on that issue?
Because there was because in this situation, the appellant raised the issue at the underlying motion when they moved to confirm and actually reject that portion of the order, and the court denied their request to do so. So I think it is an appealable order.
All right, we'll hear from your adversary on rebuttal.
Thank you, Your Honor. I think the justice is just, you got it right. There's no order. In fact, I asked for an order, never got one. Mr. Advocate just indicated that we made this argument and it was implicitly rejected. First of all, there's nothing in 439A that suggests there's an implicit confirmation. The judge either confirms it, changes it, or rejects the willfulness findings and says we're not ordering any purge amount. But the relevant portion to respond to Mr. Advocate is it's a fairly long argument by us. It wasn't me arguing it below the family court judge. My co-counsel argued it. And then this is the quote from Judge Richardson. We explained that we were looking for the court to increase the purge amount. The court said, I'm not. Those are issues squarely before the support magistrate, not me. So that is emphatically rejecting the argument that Mr. Advocate just made. Judge Richardson, for some strange reason, was obsessed with this concept that the purge amount had not been confirmed to be paid by the paperwork he received from the support magistrate, and he was concerned to find out as a threshold matter, was the money paid? There was a discussion about that. He then sent it back to the support magistrate to say, tell me definitively whether the money was paid. It never went back to Judge Richardson. Therefore, 439A was not complied with. We couldn't have appealed. There was no appealable order. Therefore, the matter must be remanded so Judge Richardson can comply with 439A and determine the appropriateness both of the purge amount and the willfulness finding. Thank you, Your Honors.
Thank you both.
Thank you.
The next case is Zymer versus the City School District and the City School District versus Zymer.
May it please the court, Jordan Harlow for the appellant principal, Nadav Zimmer. These two related matters center on two important issues, the first of which the lower court never really addressed, which is whether the Supreme Court has subject matter jurisdiction to hear an Article 75 petition that's brought to modify or vacate an arbitration decision issued to a tenured principal. And the second is, if the Supreme Court does have subject matter jurisdiction, whether the arbitrator in this matter exceeded her authority in directing the appellant principal to be reinstated to his former position, which was the principal of Harlem Renaissance High School. Regarding the first point.
Counsel, turning to the second issue, I have difficulty understanding why your position in this case isn't barred by the by the Court of Appeals decision in Adlerstein. It seems to me that that makes very clear that the arbitrator can only restore the teacher or principal in this case to a position and not to a particular school. So I don't understand. I'm having trouble understanding, and perhaps you could explain it to me, how you would distinguish that case.
Thank you, Your Honor. Regarding the Adlerstein case, this case only relates to the power to transfer teachers. So the procedures for transferring teachers versus principals are very different. They are contained in different they're contained in different provisions of both the education law and the collective bargaining agreement. And it's our position that the arbitrator Rosario properly distinguished Adlerstein from the instant matter because it related to a tenured teacher. And so for that reason, it does not prevent her from directing from making her direction. And I think it's further distinguishable because here she's not directing that a principal be transferred. So I think the lower court it focused a lot on the power to transfer principals, but that is really a separate issue. We don't have a situation here in which an arbitrator is directing that a principal be transferred. We're simply have a situation where she's directing that a principal be reinstated to the position which she actually already has pursuant to Chancellor's Regulation C30.
Counsel, what about matter of Einstein, which is another case which doesn't seem to support your position, which clearly says that you're not entitled to reinstatement at your prior school unless you're acquitted of all charges, which this petitioner was not?
Thank you, Your Honor. I think, again, there's a basic distinction here because in Einstein, the assistant principal was well, first of all, we did not have an arbitrator that directed this assistant principal be reinstated as we have here. The assistant principal simply stating that she has an automatic right to reinstatement, as opposed to whether the arbitrator has the authority to direct the principal to be reinstated. And I think that's actually a very important distinction because in the collective bargaining agreement, there are several provisions in Article 7, J4 that states in specific scenarios this principal has to be reinstated. But just because a principal has to be reinstated in those specific scenarios does not mean that an arbitrator cannot reinstate a principal in other scenarios.
Can I ask a question? Here's my question. The arbitrator derives his or her authority from either statutes or from the collective bargaining agreement. So if this specific provisions of this collective bargaining agreement don't allow the arbitrator to afford this kind of remedy, what statute are you relying on?
Your Honor, I respectfully disagree to the extent that the statutes and the collective bargaining agreement do not allow the
What are you relying on? Okay, which part of the collective bargaining agreement and which statute, rules, or regulations would give the authority?
The education law, the collective bargaining agreement, and Chancellor's Regulation C30 are all silent as to they're silent to the extent that they're silent as to who has the specific authority to reinstate a principal here. They provide for certain scenarios, for example, in which a superintendent can transfer a principal without the C30 process. But even that, those are three limited scenarios defined by outlined by Education Law 2590H. That's for persistent educational failure, conflict of interest, and ethics violation, none of which we have here. So that wouldn't apply here. But going beyond that, there is nothing that specifically prohibits an arbitrator from reinstating a principal as we hear. And further, there is nothing that states that the superintendent or the chancellor or anybody else.
Nothing, let me just follow it along so I understand your argument. If there's nothing that prohibits, you believe that we can infer from that the arbitrator has that remedy available to him or her?
Yes, Your Honor, I do, because it is routine where arbitrators will issue arbitration decisions, whether it's for principals or for teachers, in which the arbitrators have unfettered authority to issue the determinations and the penalties that they feel are right. And unless this authority is specifically delegated to the superintendent, for example, or unless there's authority that states a arbitrator cannot do this, the arbitrator is not usurping, is not exceeding her authority. There's simply not.
And that's where you depart from the lower court ruling, which essentially said there is no authority, and therefore, since it doesn't exist statutorily or in the collective bargaining agreement, she exceeded the authority in this case. So you just think that's wrong as a matter of law?
No, Your Honor. I believe that the lower court actually made an error, because the lower court made an error in determining that the lower court focused on the section X, subsection C of Chancellor's Regulation C30, which states that there are certain circumstances where a superintendent can transfer a principal without a C30 process. The lower court interpreted that provision to state that this gives general discretion to superintendents to transfer principals. And as a result, the arbitrator in making this ruling usurped that authority. However, what the lower court failed to do is recognize that that is further defined and constricted by Education Law Section 2590H, which provides for only 3 scenarios in which a superintendent can bypass Section C30. The lower court ignored or was not aware of Education Law 2590H. Had the lower court been aware of Education Law 2590H, it would have recognized that these 3 scenarios do not apply here, because there were no ethics violations, there were no conflicts of interest, and there was not a persistent educational failure that was found by the arbitrator. As such, and that was the basis on which the Supreme Court viewed that the arbitrator Rosario actually impeded the authority of the superintendent. But because that doesn't apply here, she did not impede any authority of the superintendent. And then I would just further add, though, as to that point,
I'm going to take your time is up. So you need to finish up your argument, and you can make your further point in rebuttal.
Thank you. I would just lastly state regarding the first point, I just like to point your honors to Article 7, Section J4, which states the following procedures, quote, shall be the exclusive process for removal and discipline of principals. This replaced Education Law 3020A, including subsection 5A, which calls for an Article 75 procedure. And I would just note that the respondents failed to address this in their papers, and they have no response to this providing for the exclusive process. And for that reason, we believe that the Supreme Court does not have a subject matter jurisdiction to even hear this Article 75 petition in the first place. Thank you.
Okay, thank you. Mr. Popolo?
Good afternoon, Your Honors. May it please the court. Just to briefly return to the argument about the arbitrator's authority, I think it's clear in Adlerstein, the Court of Appeals was very clear that the power of the Board of Education over placements is absolute in the absence of a contractual provision to the contrary. And here there's no provision to the contrary. If anything, Education Law 2590-8, provides for the chancellor's right and power to transfer principals. And not only did they not waive that, they explicitly reserved it in the collective bargaining agreement. And that's in Section 7, Article 7, Section J4 at page 205 of the record. So I think for all the reasons that Your Honors already went through here, there's clearly no delegation to an arbitrator of that power. I mean, it was explicitly reserved by the DOA, and Adlerstein and the Education Law and Einhorn all support the notion that the arbitrator exceeded her power in ordering the reinstatement to a specific school. I mean, for example, in Adlerstein, the Court of Appeals said that, the language shall be restored to his position, which, as Justice Kern pointed out, doesn't even apply here because Mr. Zeimer was not acquitted of all the charges against him. But even if he had been, the language shall be restored to his position does not necessarily mean that he must be returned to the same position in the same building from which he was suspended. So there's no basis to displace the DOA's exclusive right to place pedagogical staff. With respect to the jurisdictional question, the portion of the collective bargaining agreement that says that the following procedure shall be the exclusive process for removal and discipline of principals, it doesn't say that the process that you no longer have the ability to challenge an arbitration award on the grounds that it exceeded an arbitrator's authority. I mean, on the next page, there is a provision that talks about modification of 3020A procedure, and that's on page 206 of the record. So Mr. Harlow is correct that you can, under the educational law, have the right to modify the 3020A procedures. But here in the specific provision of the collective bargaining agreement that speaks to those modifications, nowhere does it say that they are eliminating the statutory right to seek review under Article 75 on the grounds that an arbitration award exceeded the arbitrator's authority. And for as we set forth in our brief, any waiver of a statutory right like that has to be expressed and affirmative. It can't be read into a collective bargaining agreement by implication. And it's clearly not expressed and affirmative here. And that's, just trying to think if there's anything else.
Any further questions, colleagues? All right, Mr. Harlow, we'll hear from you on rebuttal.
Thank you, Your Honor. I'd just like to address the last point by Department Counsel, or the first, that regarding subject matter jurisdiction. Again, I would note that the right for a pedagogue to pursue an Article 75 petition challenging an arbitration decision comes from such Education Law Section 3020A 5A. And this Section 3020A was replaced by Article 7J4. If you look at the intent of the legislative history, this what's contained in Article 7J4 was actually contained in a memorandum submitted by the senators as the reason why they're passing Education Law Section 3 in the first place, so that these provisions can be modified. And it's clearly evidence that there was an intent to replace and modify all of Section 3020A 5A. And if the intent was for this procedure to be optional, it would not have been contained within Article 7. It would have been given its own article. However, it is part of Article 7.
Doesn't it say, though, Counsel, that the Chancellor may review? Isn't that non-mandatory?
Well, Your Honor, that comes after Section J4, which states that this would be the exclusive review. And the way I read may review is that if it's stated shall review, then it could be interpreted that the arbitration decision itself will not be final until one party seeks the review. But I would believe, but the intent was that just as in Article 75, it's just as for a teacher, it is not necessary for a teacher or the department to seek Article 75 review in order for the decision to be final or have weight. Here, a decision can be final if neither party seeks review. But if either party were to seek review, the exclusive process is that contained in Article 7, as stated by Article 7J4. Seeing no further questions, thank you, Your Honor.
Thank you. The next case is People versus Jose Feliciano.
Good afternoon, Your Honors. Claudia Troop on behalf of Jose Feliciano. In this case, Mr. Feliciano was prejudiced by the courts employing a double jury procedure and refusing to grant the complete severance, which the defense requested. There was no dispute between the parties.
This is Justice Kennedy. And I want to ask you, how would you respond to the people's argument that you failed to preserve this with respect to the double jury?
Thank you, Your Honor. So prior to trial, the co-defendants counsel filed a motion for complete severance. And in that motion, I want to read it to you because it's very specific, and I'd like to read the language to you. What he said was, as counsel for Mr. Roberts, I intend to use my cross-examination opportunities in regard to any witness proffered by the prosecution to drive home to the jury the overwhelming evidence of complicity and guilt of Mr. Feliciano in regard to these crimes. And Mr. Feliciano's counsel explicitly joined that motion. And so by joining that motion, by joining that argument, we preserved this issue for this court's review on appeal. And true to his word, the co-defendant's attorney did use his cross-examination at every opportunity to drive home Mr. Feliciano's alleged guilt of this crime. And there's no doubt that it was conceded that these defenses were absolutely contradictory and in conflict with each other. Mr. Feliciano's defense was that he was merely present at the time of the shooting. And the prosecution's witnesses actually supported that defense. For example, Noel Mota testified that immediately before the incident, the deceased and Mr. Feliciano were together at where Mota was, at Mr. Feliciano's apartment. He shared with his girlfriend, and that there was no conflict between Mr. Feliciano and the deceased, that they were friendly, and that it was the deceased who suggested to Mr. Feliciano that they return to the deceased's apartment so that the deceased could repay him money that he owed him. Mr. Mota also testified that after they returned after the incident, after Mr. Feliciano returned to the apartment after the incident, that he was distraught and that he said to the co-defendant, Mr. Roberts, he asked him, "Why did you do that? Why did you shoot him?" Suggesting that he was shocked and upset by the crime. The prosecutor could not impeach that testimony by his own witness, but fortunately for the prosecution, the co-defendant's attorney could. And the co-defendant's attorney impeached Mr. Mota by attempting to impeach him with prior grand jury testimony, suggesting that Mr. Feliciano was angry at the deceased because he had propositioned him for sex, and that was the motive for this murder. Similarly, he suggested that Mr. Mota was lying to protect Mr. Feliciano, even though Mr. Mota's testimony was largely in support of Mr. Feliciano's defense. This could also be seen in the similar type of attack could also be seen in the testimony of Mariano Figueroa. Mariano Figueroa testified that it was the co-defendant who had given him the murder weapon after the incident, again, supporting Mr. Feliciano's mere presence defense. Co-defendant's counsel cross-examined Mr. Figueroa and suggested that he was lying again to cover up for Mr. Feliciano. Similarly, again, with the testimony of Stephanie Rivera, who, like Mr. Mota, had testified that she was in the apartment with the victim and with Mr. Feliciano prior to the offense. There was no conflict between them. They were on good terms. They were friendly, and that he was again upset when Mr. Feliciano was upset when he returned and questioned the co-defendant about why he committed this crime. Again, the prosecutor, the co-defendant's attorney, acting as a second prosecutor, impeached Stephanie Rivera with a prior inconsistent statement suggesting that Mr. Feliciano was upset and violent prior to the incident and that he was cursing and high at the time of the incident. So again, acting as a second prosecutor throughout these proceedings, undermining the defense. And this is why we were entitled to severance in this instance. The court refused to grant it, and this prejudice was throughout the trial, throughout the course of the trial. The co-defendant's attorney also elicited consciousness of guilt evidence that the prosecution didn't elicit with respect to the Rikers calls, suggesting that Mr. Feliciano was familiar with how to borrow another inmate's number so that he could talk without being detected by the prosecution. This was not information that the prosecution elicited or was entitled to elicit, and it was extremely prejudicial throughout this trial. And in fact, the co-defendant's counsel was so aggressive and towards the witnesses that the prosecutor often objected and accused him of badgering the witnesses and acting in an inappropriate manner. And he was very successful because even though it was the prosecution's theory that co-defendant Roberts was the shooter in this incident, he was acquitted of all charges. And Mr. Feliciano is the sole person who is now been imprisoned for these offenses, which brings me to the second point I'd like to argue, which is the excessiveness of this sentence. Mr. Feliciano is currently serving 25 years to life for the murder and 12 years for the robbery of another man, Mr. Abreu. Under anybody's theory of the case, the prosecution's theory of this case, this was a felony murder. And so this was not an intentional murder on behalf of even under the people's theory, the person who did the shooting was Mr. Roberts. This was the main reason why the prosecution at sentencing advocated for the maximum consecutive sentences is because Mr. Feliciano would not cooperate against the co-defendant and he would not plead guilty. But of course, Mr. Feliciano was constitutionally entitled to insist that he was merely present and to insist on a trial. And that wasn't a basis for enhancing the sentence to the maximum of consecutive time on these cases, when by anybody's theory, this was simply a felony murder where he was not the shooter. Also, Mr. Feliciano's background is worthy of some sympathy by this court. He was raised by both his parents were drug addicts. He became addicted to drugs as a result at a very young age, and he has struggled throughout his life with that addiction. However, prior to this crime, he had been in a long-term relationship for 10 years. He had a 6-year-old daughter, and he was attempting to function. So the maximum sentences that were imposed mean that the parole board will not even be able to look at Mr. Feliciano's eligibility for parole until 2049, when he's 70 years old. This is not a case, given the actions that are attributed to him by the prosecution, where he deserves the maximum consecutive sentences. And a reduction here will simply mean that the parole board at an earlier date can assess Mr. Feliciano's readiness to return to society. And we would ask that your honors reduce the sentence here in the interest of justice, because it's simply unfair that for a felony murder where the shooter was acquitted, that Mr. Feliciano is serving the maximum consecutive terms of imprisonment. Thank you.
Thank you.
May it please the court, Rafael Corbello for the people. The defendant's severance issue is not preserved for appellate review. It was co-defendant's counsel who had moved.
Yeah, but it's true enough. It was the co-defendant's original motion, but they're like Siamese twins, aren't they? I mean, they're hard to separate out. If the defenses are antagonistic to each other, and that's the basis for severance, then it applies to both, does it not? Can you ever have it where it's antagonistic to one and not the other? And did that exist here?
The defendant's defense was that he was not the one who committed the murder.
And he didn't share an intent, so he didn't come in on the felony murder, right? The co-defendant said he wasn't there, right?
Correct. So,
well,
he
also had a defense. It wasn't me in any event, even if I were there, not saying I was there, it was Mr. Feliciano. No?
Right, that I'm sorry, the co-defendant, no, the co-defendant argued that he wasn't there.
Period.
That's it. That the other individual was Mr. Nadal. And so was how the defense came out on the cross-examination of the people's witnesses, that co-counsel was trying to pin the guilt on Stephanie Rivera's boy.
Counsel, can we go back 1 minute? Because before we even get into the merits, I still haven't heard you argue why preservation is not available. If co-counsel joined in on the motion, why wasn't that enough to preserve the objection?
It was a one-page affirmation that counsel submitted, stating that in response to the people's objection to co-counsel's motion papers, the people said, if the defendant, Mr. Feliciano, would testify, I was just there and did nothing while Michael Roberts killed the victim, then that would be an antagonistic defense.
But it seems to me that that one-page affirmation to the joining in on co-defendant's motion. And however many pages he took to join it, it seems to me that once he joined it, he preserved that issue. Could you explain why that isn't preservation?
Well, because he argued that defendant might testify in a manner that was antagonistic to the co-defendant. Didn't adopt any other arguments explicitly or implicitly. As a matter of fact, when the judge decided to hold a double jury, counsel acquiesced and agreed to the double jury because his
That was
client.
only after the objection had been overruled about the severance.
I'm sorry?
That was only after the objection had been overruled about the severance, after only the judge did not allow the severance of the cases. Let me just go on a minute. Why aren't their defenses completely antagonistic in such a way that would completely prejudice the defendant by having the cases heard together, even with separate juries?
Because the co-defendant's defense is, I wasn't there, it wasn't me, and that in no way reduces or increases the defendant's culpability. The co-defendant saying Noel Mota was the second individual, not me. But defendant admitted from the very beginning that he was in fact present.
But if his whole position is he wasn't present and Roberts was the shooter and Roberts saying I wasn't there, doesn't that make him out to be inherently incredible if you believe Roberts' position? That he's just lying.
But if you have two separate juries, defendant's jury was not tasked with finding a co-defendant guilty or not guilty. They were not tasked with determining whether the co-defendant was credible or incredible.
Did they hear? It's not a question of what they were tasked with. True enough, the juries were tasked with two different things. But did they hear evidence that would not have been available had, in fact, there been a severance? So, in other words, your adversary raises the fact that there was very aggressive cross-examination of the people's witnesses, Moto, Figueroa, and Rivera. They were called by the people, and that you could not have cross-examined them to the extent of impugning their credibility in support of Feliciano, but because co-counsel was there for co-defendant, that could happen. Where's the problem in that argument?
Well, but the co-counsel's objective was to pin the blame on Noel Mota, not to in any way, shape, or form.
But we know what their motive was. But why wouldn't that information prejudice Mr. Feliciano?
There is admittedly some inherent prejudice in any time you have two defendants in front of one jury, or even in the split jury situation that we had here. And so the question becomes is whether or not the degree of prejudice was so egregious as to warrant reversal. I don't think this is a case where Jose Feliciano was deprived of a fair trial because there were two separate juries here. Yes, there is going to be a degree of prejudice. There's no denying that.
Counsel, wouldn't you agree that his co-defendant's counsel was able to cross-examine witnesses to Mr. Feliciano's detriment in a way that the people could not, and that in effect caused him to be in a much more prejudiced position than if he'd been tried separately?
Well, I mean, one of the witnesses, Stephanie Rivera, defendant's jury did not hear co-counsel's cross-examination of Stephanie Rivera. Mr. Figueroa and Mr. Mota, co-counsel elicited that perhaps they were biased in favor of the defendant because they're related to him, they're family, and you don't need a co-counsel to bring that out. The jury knew that, and the jury could infer bias given the familiar relationship of these individuals.
Counsel, if I may, since we're talking about Stephanie Rivera, can you address the fact that during summations, a statement that she gave, which was pretty damaging to the defendant, was presented during summations and also given to the jury, even though it wasn't admitted into the defendant's case? Can you address that?
Yes, admittedly, that should not have happened because that statement was not admitted against the defendant. But
how is that not prejudicial? Because it was pretty, damaging toward him.
Well, given the charges that the defendant was on trial for, the testimony and the statement more or less coalesced. There's the things in the statement that did not come out at trial really had nothing to do, or very little, if anything, to do with the charges that the defendant was on trial for. For example, he stated that he and his wife had gotten into an argument earlier that evening. And in the statement, we know what that argument was about. It was about his drug use. But that doesn't go to his role in the homicide of Francisco Restitulo. It doesn't go to his role in the robbery of Adrian Abreu. The matters that were in her written statement that were not otherwise elicited at trial did not add anything or added very little to the defendant's role for the crimes for which he was on trial. And so that's why we think that we admit that there was error, but we think it was a harmless error in the aggregate.
All right, thank you. Ms. Trupp, any rebuttal?
Yeah, I would just like to address the Stephanie Rivera statement. That was an extremely prejudicial statement. It depicted Mr. Feliciano as acting in a drugged and violent manner immediately before the incident. It depicted him as throwing things and cursing, which suggests that he was not in control of his temper and was altered at the time immediately before the incident. And tellingly, while this should not have been admitted, it's conceded by the prosecution that this was improperly admitted to Mr. Feliciano's jury. It was the sole exhibit that the jurors asked to see, that extremely prejudicial statement by Stephanie Rivera that they asked to see during the deliberations. Given the prejudicial nature of that statement, given the jury's reliance on it, there's no way to say that that aspect of conceded error can be deemed harmless. And so for that reason, and for all the others I've mentioned in our brief and in our argument, we would request that the conviction be reversed and a new trial ordered. Thank you.
Thank you. Okay, the next case is Preserve Our Brooklyn versus City of New York.
Good afternoon, Your Honors. Eric Lee for the city respondents. This court should affirm Supreme Court's order. I wish to make two brief points, the first on zoning and the second on SECRA. On zoning, because zoning ordinances enjoy the strongest presumption of validity, the petitioners have the heavy burden to show that the rezoning of the church's lot was invalid beyond a reasonable doubt. They failed to carry that burden, and here's why. First, the rezoning advances the city's interest in creating affordable housing near transit corridors. This will be a 100% affordable housing development 2 blocks away from 12 different subway lines. Close to half of the units will be permanently affordable, and the rest will be affordable for the next 40 years. And because of the rezoning, affordable housing will be mandatory on this site. The rezoning also dovetails with the rest of the block and the surrounding area. The block borders the downtown Brooklyn Special District, and as I mentioned, Atlantic Terminal and Atlantic Center, a mall, are directly to the west and south of the block.
Counsel, isn't it true, though, that the building that will result in this is much higher than the brownstone buildings in the immediate neighborhood?
That's not true, Your Honor. Just 10% of this block is made of townhouses, and in fact, the proposed 13-story building already is on a block that has 2 15-story buildings, a 12-story building, and an 8-story commercial building, several of those which are actually exceed the bulk requirements of what the zoning will result in. I think it's also important to remember that as part of the 2007 Fort Greene rezoning that the petitioners talk often about, this very lot and the northern portion of this block was rezoned to increase and to encourage dense mixed-use growth and affordable housing. So the bottom line is the rezoning will advance the city's housing goals without disturbing the neighborhood's character. Unless the court has any questions about the zoning, I'm going to move to the secret point. Here, the city's environmental review was not arbitrary and capricious. Petitioners basically have nothing to say about the city's seeker analysis, and that alone warrants affirmance here. As this court recently reaffirmed in Northern Manhattan, the city is entitled to rely on the seeker technical manual in conducting its review, and that's exactly what the city did here. In the opening brief, the petitioners complained that the city ignored the 2007 rezoning plan. But if you look at the environmental review, if you look at the record, the city didn't. The city, in fact, said that this was consistent with what the Fort Greene rezoning plan envisioned for this particular block and this particular lot. In the reply brief, the petitioners try a slightly different tack. They say that the city didn't consider whether this rezoning will increase affordable housing compared to that 2007 plan. But the city did consider that question, and the answer is a resounding yes. The rezoning here will actually increase and create more affordable housing. In fact, it is because that the city is willing to rezone the lot that the church is building affordable housing. Without it, the record is clear that the church and the developer would have built a new community facility, but with market-priced condominiums, which is not consistent with what the city would have liked to do with this lot. And to the extent that the petitioners now take umbrage with the limited scope of the seeker review process, as this court said in Northern Manhattan, this argument is really raised to the legislative body that periodically revises the criteria in the manual, and that's not a basis here to say that the environmental review was arbitrary and capricious. At the end of the day, is there a question, Your Honor?
No, you're just way beyond the time that was allotted to you, so I'm allowing you a few.
Sure, just
to
wrap
finish up.
Yes, of course. The bottom line here is that petitioners just disagree with the city's legislative judgment and policy priorities. That's not a basis, however, to invalidate this environmental review and their zoning. Thank you, Your Honors.
Thank you. We'll hear from co-respondent South Portland. Mr. Lobel?
Your Honors, Richard Lobel of Sheldon Lobel PC. Can you hear me?
Yes.
Thank you, Your Honor. Your Honor, we would merely echo the statements by Mr. Lee with regards to the lower court's decision and the appropriateness of that decision. The issues here basically revolved around the legitimacy of the rezoning action as well as the legitimacy of the environmental review. The petitioners make allegations with regards to spot zoning despite not setting forth the standards for such accusation in their papers. And really, as this court set forth in Residents for Reasonable Development versus City of New York, decided in 2015, a zoning map amendment does not constitute illegal spot zoning merely because it involves a single parcel only. The real question is whether or not there was a comprehensive plan that was put forth in the discussion and the deciding upon the rezoning. And here, as Mr. Lee mentioned, there was a comprehensive plan, particularly because this was in an area which was transit rich. This is on a block where merely a fraction of the existing lots have lower density buildings. This is going to create mandatory inclusionary housing. When the petitioners looked at the prior 2007 rezoning, that rezoning was done in a time where mandatory inclusionary housing was not part of the zoning resolution. That was introduced in 2016. So this rezoning now carries with it a requirement that any residential redevelopment of a minimum size, which this parcel would meet, must contain affordable housing. And that is a valid and demonstrated goal of the city. And similarly here, the environmental review was done in an appropriate manner, both under SECRA and city seeker. The requirement is that the agencies took the necessary hard look. This is the bar, the standard here is a very high standard to the extent that there was a environmental assessment statement, which looked at over 15 impact categories, which looked at literally over 200 pages of environmental review. All the necessary review was done, and this was vetted in the public Euler process. The Euler process, which reviewed both the zoning and environmental findings here, was a decidedly public process. This is governed by the city charter, and involves review by the local community board, by the affected borough president, by city planning, and by the council. So all of those hearings took place. Those objecting to the rezoning and to the environmental review had an opportunity to be heard. This rezoning was done entirely in accordance with law and regulation. And so we would ask this court to affirm the decision of the lower court and find that the rezoning and environmental review here were valid.
Thank you.
Thank you, Your Honors.
Okay, the next case is Rank versus Rank.
May it please the court, Fred Bronstein from the Robbins Kaplan Law Firm for Appellants. I'd like to briefly address three main points where we believe the lower court erred: the statute of limitations, the claims against appellants Linda and Sequin specifically, and the consideration issue. First, with respect to the statute of limitations, at issue here is a purported oral contract that Ms. Rank admits was breached over 20 years ago. Pursuant to the only alleged term of this contract, Richard, Ms. Rank's father, has been in breach since 1999.
Counsel, this is Judge Kern. What about GOL 17101? Why isn't that applicable based on the codicil where there was a clear acknowledgement of this contract or promise?
Sure, I have 2 points on that. First, there's actually, before getting to those, I want to be clear on what the promise is, because I believe there's daylight between that and the codicil. The promise here is that Richard would serve as a trustee for a 50% interest in the company, and that he thus owes not just his current 45% interest in Sequin, but also a 5% interest that has been transferred to RJ, his son, and then also all associated distributions that were ever made to either of them over the past 20 years. The codicil does not specify a 50% interest, and it's also silent about any company distributions that Ms. Rank claims she's entitled to. Furthermore, courts interpreting 17101 haven't just looked to a particular sentence, which I believe you're looking at in the first paragraph. They've looked at the entire document and other contemporaneous written correspondence to determine if there's an unqualified and unconditional promise, or if there's instead something inconsistent.
Except, counsel, it seems to me that your argument goes to whether or not the codicil stated the promise, as opposed to whether the codicil revived the claim for the purposes of statute of limitations, which it seems to me is quite different. So I don't understand. I'm having trouble understanding why your explanation of the slight difference between the codicil and the underlying agreement would deprive the codicil of the effect of reviving the statute of limitations or extending the statute of limitations.
Sure. I have 2 points on that. One is that the codicil does not treat this interest in question as Ms. Rank's property, which is the promise here, that this is her interest as opposed to Richard's. In fact, if you read the entire will, it treats the document as Richard's property, which makes sense. It's part of his will. He's distributing assets. It provides.
Well, interestingly enough, it's a statement of present intent and not really consistent with a will, which is what happens upon my death. He's like, I'm going to give this to her as soon as I can. Doesn't that deal with an inter vivos promise? And isn't that distinguishable from whatever he's doing in his will with his own property?
It's all within the same document, Your Honor. So it's
understood. I understand, but this isn't a testamentary disposition. It can't be, right? You'll allow me that.
I'm not sure what you're asking, Your Honor.
You said we have to look at the whole document. The whole document is a will. What am I going to do with my property? Or what gets done with my property when I die? But this particular aspect, although it's contained within the will, is really something different. He's not talking about what he's going to do when he dies. He's talking about an inter vivos transfer of the property. And that distinguishes it, at least for me it does. And the question is, does that raise an issue of fact under the general obligations law?
The answer to that is no, Your Honor, both because of the later portion of that document where Mr. Rank definitively treats this as his property as opposed to Ms. Rank's, and then also how the parties actually interpreted that document at the time. If you look at Ms. Rank's response to this document, her response isn't, great, thank you, now I have a formal written acknowledgement of the promise. Her response is literally the opposite. She says, this document, I'm dismayed by this document. My attorney has advised me that this document is contrary to the facts of the ownership. And then she immediately sends Richard a letter asking him to sign on to affirm that she has always been and will continue to be the beneficiary of 50% of the ownership interest in Sequin LLC, whether held in Richard's name or a subsequent transferee. And Richard refused to sign that document. So what that tells us is that Ms. Rank did not treat this document as reaffirming this promise, that Richard did not intend this document to reaffirm this promise, and the document itself, grant you, there's one sentence there. The rest of it treats it as Richard's property. That document is inconsistent with the promise. So taken together, there's no question of fact there that this promise, that the codicil does not reaffirm this promise pursuant to 17101.
Okay, thank you. You'll have time on rebuttal. All right.
Thank you, Your Honor.
Vergara, go ahead.
Thank you, Your Honor. May it please the court. As far as the General Obligations Law 17101 issue, all that is needed to revive a statute of limitations is an acknowledgement of an existing debt, and nothing inconsistent in that writing with that understanding of an existing debt. Paragraph 1 of that codicil, as Justice Gish pointed out, does exactly that in the present intention of Richard Sr. He explicitly says, I am holding an ownership interest for my daughter, Kimberly Rank, in the jewelry company, Sequin. That's all that's needed to revive the statute of limitations as of November 2013.
Well, actually, he says more. He says, I'm going to give it to her. That's actually what you would need for the General Obligations Law.
Absolutely correct, Your Honor. He says, I'm going to give it to her as soon as possible. And
that means, let me ask you a question, though. I mean, as I understood the lower court decision, is that the court didn't make a definitive determination that you were within the statute of limitations, correct?
Your Honor, the court analyzed both general obligations law and did an equitable estoppel analysis. And I submit that the codicil—
It gave you the benefit of pleadings. It didn't resolve the issue as best I understand it. It said the issue, you raise enough for pleading purposes to get to the next level, correct?
Correct, Your Honor. It's critical to keep in mind that this is a CPLR 3211 motion. And
I'm keeping it in mind, and that works to your benefit.
That's correct, Your Honor.
Right, but the issue is still up for grabs, if you're right.
Well, yes, Your Honor. The issue is still up for grabs. It could be determined on a summary judgment motion basis, one way or the other. It is up for grabs. This was a 3211 motion. We had the benefit of an extensive complaint, and we had the benefit of deposition testimony. I think it can be conclusively established in Kimberly Rank's favor that defendants are not entitled to a statute of limitations defense. But I think Your Honor is correct in pointing out—
We don't need to get there. We don't get there on this appeal.
I believe you're correct, Your Honor.
Okay.
And you know that was the only thing that was raised. To the extent that on rebuttal, the appellants will argue other factors such as consideration and the issue about Linda and Sequin being defendants in this case. I'm happy to answer questions, but the consideration is a very easy one. Kimberly Rink gave her ownership interest in Sequin to her father to hold in trust at the very founding of Sequin. That is consideration. She also, along with that consideration, gave the benefit of her talent, the benefit of the connections, establishing a supply chain, the benefit of the design talent for the costume jewelry business that only she knew about as far as the founding members are concerned. So there is ample consideration, as Justice Ostriger determined in the motion court below. As far as...
This is Justice Kennedy, and I would like to go back. How do you address the defendant's arguments that the 2013 codicil had no effect because there were no writings to memorialize the agreements between the years 2006 and 2013? Can you address that?
Sure. The motion court determined that it was an oral contract that was made in 1999. The effect of the codicil is for purposes of reviving under general obligations law. We don't need any writings. There were subsequent writings. Appellant's counsel referred to Kimberly Rank writing to her parents and asking for more after the codicil. And it's true, the codicil did not affect the transfer. The transfer was not consummated by virtue of the codicil. Kimberly Rank wanted what was hers, what has been promised to her for almost 2 decades before bringing this lawsuit. And she was told by attorneys, look, that codicil didn't affect the transfer. And she was merely complaining about wanting the understanding to finally being fulfilled after almost 2 decades. But it was, Justice Kennedy, it was an oral contract as far as what Justice Ostriger found, and I don't believe the appellants challenge that fact. I mean, there are no writings at the founding of Sequin.
All right, we'll hear a rebuttal from your adversary.
Thank you, Your Honor.
Mr. Blumstein, go ahead.
With respect to the codicil, I would just direct the court to a case we cite in the brief, matter of Hollis from the Second Department, where that court had a somewhat similar situation where there was, in that case, emails acknowledging a specific amount of a debt, there $140,000, and statements that said, I intend to pay that debt. But the court said there was no question of fact because there was other inconsistent language. Similarly here, the inconsistent language in the codicil, the treating of this interest as
was that summary judgment or a motion to dismiss?
That case was at summary judgment, but the court only relied on the emails themselves. There was no other evidence that got submitted. So it was just the writings themselves did not create an issue. Similarly here, the codicil does not create, there's
Well, it is, but it's a different standard. You're relying on it's a different standard though. I mean,
the issue for 17101 is whether there's an unequivocal and unqualified acknowledgement of the debt or not. If there's doubt about it, there's no question of fact over whether it's unequivocal or not. That's what unequivocal a document is. So here, where there's inconsistent language, it necessarily can't be unequivocal. And we know the parties didn't treat it as such since the follow-up was asking for further clarification. So I refer the court to that case and also the Pugny v. Giannini case, which also involved multiple inconsistent writings. And that one was at the motion to dismiss stage. With respect to the other two issues, I'd like to address the consideration point. All of the items that were just mentioned are not benefits to Richard. Transferring an interest for one to hold in trust is not anything, it's not conferring a benefit on Richard. He's not getting anything out of that other than really an obligation to hold the interest. The same thing goes for Miss Rank working for the company. If Richard is only a trustee for an interest for Miss Rank, he's not receiving any benefit of the bargain here. All he's doing is agreeing to hold an interest and then give it back to Miss Rank. That is just a non-binding promise. It's not a contract. And the consequence of that is that there's nothing for this codicil to revive if there's no consideration for this agreement.
Okay, I think we understand that argument. And you're out of time, so I'll give you another minute to finish and wrap it up.
Thank you, Your Honor. The only other point I'd like to make is that there are no allegations here against either Linda or Sequin, and nevertheless, keeping them in the case, the lower court erred. Linda owns a 50% interest in the company. Ms. Rank has no dispute over her ownership of that 50% interest, yet she purports to allege unjust enrichment, constructive trust, and accounting claims against her. The persons who allegedly hold the interest that Ms. Rank claims entitlement to are Richard and RJ, not Linda. As she has no claim against Linda's interest, she has no claim that Linda received distributions that belonged to herself, to Ms. Rank. So the claims against Linda should have been dismissed. Similarly, Sequin itself does not have any of Ms. Rank's ownership interests. It's to the extent anyone has them improperly, it's Richard and RJ. So
right, we understand. We understand. All right.
Thank you, Your Honor.
Thank you. Panettone versus Scout.
Good afternoon, Your Honor. May it please the court. My name is Joseph Perry with the law firm Baker Botts LLP on behalf of Appellate Scout Fund. I'm here today, Your Honor, to introduce my colleague and ask the court's permission that David Genender of the State Bar of Texas be permitted to participate in this appeal and argue before the court.
Okay. Your application is granted. Thank you. All right, we'll hear from the respondent as well, has a pro hoc vice application.
Thank you, Your Honor. May it please the court, I'm Charles Cummings, a member of the Bar of the State of New York, and a member of Baker and McKenzie, counsel in this matter for the plaintiff respondent. I'm pleased to introduce my partner, Daniel J. O'Connor of the Illinois Bar, who appears today to argue this appeal with Your Honor's permission.
He has my permission. Thank you both.
Thank you.
Let's start first with the appellant. Sir?
May it please the court. Thank you for permitting me to argue today on behalf of Scout Fund. The central issue in the trial below and before this court is relatively simple. What does it mean to engage and to use an investment manager? This court in an earlier appeal told us how we go about answering that question. We look at the contracts. We look at the contracts between Scout Fund and Panettone. Specifically, there was an investment management contract that made it plain that to be engaged and to be used as an investment manager, you must have access to capital provided by an investor with which you will buy assets, manage assets, and sell assets. That standard of buying, selling, and managing is universal in the evidence below. It's in the New York Common Definition, it's in ERISA, it's in the Form ADV, and it's in the Investor Advisors Act. And there,
at the trial level, one of the factual questions was whether a third entity principal didn't act as investment manager. Why wasn't, even under the decision that we previously rendered, the court free to decide, looking at all of the facts, that principal and not here Panettone was the investment manager?
If the evidence, Your Honor, had been that principal discharged the touchstone requirements of an investment manager with respect to these investments, of receiving capital, buying, selling, and managing, the court certainly could have found that way. But the undisputed evidence below was that Principal didn't do those things, and in fact, only Panattoni did. Go ahead. I'm sorry, Your Honor.
I didn't say it's just tech stuff, right? Right. It's just tech stuff. It's, you know, it's me trying to watch the timer. That's my cell phone, okay?
So I have a question.
Yeah.
That in order for us to adopt your position and reverse the trial court, we would have to reject the trial court's findings of fact, and in particular, its findings as to credibility. That's something we do very rarely where there's a bench trial. Why is this the extraordinary case where we should reject the trial court's findings as to credibility?
Your Honor, you do not need to, this panel does not need to reject the trial court's findings on credibility. The undisputed facts from their witnesses establish our case. The Hain-Hamilton memo, it's exhibit 36 in the record below, and the testimony about it is in, I think it's volume 4, it's record 868 to 877, establishes that Panattoni was providing investment management services. It's undisputed that what they were doing was investment management. Mike DeRay from CalSTRS testified, not from Scout Fund. He testified that for these investments, PanCal and CP Logistics, Panattoni did the buying and the selling, not Principal. Principal admitted, it was Mr. Bellecci, who was one of the two gentlemen involved. They have no power over these investments, the joint venture, or Panattoni. They have no power to buy, sell, or bind these ventures. You can rule on this appeal by looking at the contract.
Who made the decisions about what to buy and sell, though?
Your Honor, that's a great question. Panattoni was charged with sourcing, identifying potential investments, just like it was when it was the investment manager for PI Fund. So in the initial instance, Panattoni identifies it. In this case, Panattoni did not have discretion to then act on that investment without getting the investor's approval. So that package would go up to a management committee, much like it might go up to a board of directors, who would have to approve it, CalSTRS having retained the power to approve individual investment decisions. But when it came time to manage, to execute, to do all the things that are identified, there's 30 or 40 or 50 of them in that Hain-Hamilton memo. Panattoni was contractually obligated to do all of them. Principal was obligated to do none of them. Principal was a purely passive with respect to these investments. They had no control over the assets, no power over the ventures. And remember, this investment, Your Honors, is comprised of two parts. There's the CalSTRS investment, but then there's a co-investment by Panattoni. That's the entire investment. Panattoni is the only party that had authority to act and manage with respect to the investment. What Panattoni has argued in their briefing is that somehow Principal is the investment manager for CalSTRS, but that's not how it works. The definition in this case talks about being engaged and utilized as an investment manager with respect to the investment, not for the investor. You invest, an institutional investor will put money into a fund, and then that fund has a manager. And in this case, under our documents, these PanCal joint ventures are absolutely funds, as defined in the PIM agreement. And the manager, they changed it to say administrator, but it's manager. If the court looks at the TPG agreement, a little bit of the weeds, CalSTRS calls them managers everywhere else except for this one case where they changed the name because Scout Fund said we may get to participate. So the documents went back and got changed, and manager got scrubbed out of them and instead used this term administrator. But they admit, their own lawyers admit, it didn't change the substance. And the substance, Your Honors, is that Panattoni was doing everything that it did as the investment manager for PI Fund. It was doing the exact same thing, perhaps even more, for these ventures. So when you look at the definition of a PI program, did CalSTRS engage a third party? Sure, they hired Principal, but not to be utilized. We've got to give both of those parts of the definition meaning. They were being utilized in a different capacity. And one of the exhibits that was not admitted, it went up on the screen at trial when with a witness. I think it was D102. It was a 2018. It was literally right before trial when CalSTRS published for the first time a review by their consultant, which made clear that other investment managers' principal acts more like an independent fiduciary, which is not a manager, whereas CBRE, another of their managers, actually managed and bought and sold investments. And it's really critical that the court didn't consider that, because if you are an independent fiduciary, which is the role.
But how can we consider that? You're talking about an exhibit that we didn't see, that it's not in the record.
It is in the record, Your Honor, for preservation purposes. We made an offer of proof at trial, and it was included in the record.
So, but we can't consider it. The only thing that we could consider is if there was an error in not admitting it.
Absolutely, Your Honor. Absolutely. That's correct. And we argue there was an error in not admitting it. In the same way that there was an error in not admitting the revisions, the drafts of these documents after Scout Fund brought up to Panettone, hey, we think this is something that should be in our program. They went about revising over and over. They came up with replacement terms for management fees got scrubbed out of these documents and replaced with transaction fees. We believe those documents, which were not admitted to interpret the documents that CalSTRS had with Panettone, it's not parole evidence. It was being offered to show that Panettone realized they had a problem with our documents. Otherwise, they wouldn't have needed to redo all these documents that had already been finalized.
But the documents didn't define, or the documents between these parties didn't define investment manager, correct?
Your Honor, that's correct. There was
right.
not.
Right. All right, just follow me through. Let me just finish my line of questioning. So then what was wrong? And the court below said, we're not going to be limited by the fact that a label is given to any particular party. We're going to look at what they actually do, correct?
The court purported to do that, Your Honor. We don't believe that the court did, but yes.
Well, the court acknowledged that that was what you should do, right?
Yes.
So your idea about that they scrub terms out of the documents doesn't really, I'm just not sure what it bears on if we're looking at the reality of what they actually did in order to figure out if they were an investment manager or something else.
Yes, Your Honor, it was an evidentiary point. I perhaps spent too much time on it. It is more of a trial point than perhaps an appeal point. But the court is correct that you do need to look at what Panettone did. And what they did do was everything an investment manager does. And what Principal did was provide advice to an investor without any access to capital, without any power to execute or manage.
Okay, I think we understand your argument. You'll have some time on rebuttal. Let's hear from your adversary.
Good afternoon, Your Honor. Dan O'Connor for Panettone. Can you hear me, Your Honor?
We can. We can hear you. We can see you.
Thank you. I'm pleased to make this presentation today on behalf of Panettone. This case has been a long slug. I think we filed it almost 9 years ago. The dispute was brewing for a couple years before that. We've been up here once before, and now we're here again. We've had a long trial. I believe the question was asked of Mr. Genender, wasn't it fair? Wasn't the trial judge free to decide whether Principal was the investment manager for CalSTRS? Of course, the answer is yes. In this court's decision previously remanding this case, it identified a tribal issue of fact as follows. A tribal issue of fact as to whether CalSTRS used Principal as an investment manager with respect to two joint ventures, PanCal and CP, between CalSTRS and Panettone. So that was the issue that was really tried. And that's the issue that Judge Sherwood heard days and days of testimony on. What Principal actually did for CalSTRS. Hours and hours, hundreds of pages of deposition, of trial testimony. Now, before the trial, Scout's position was that it needed a trial and that credibility of the witnesses would be important. This is discussed on our brief, page 3, their citation. Well, we've had a trial now, and Scout's position seems to be that the court's credibility determinations should be thrown out. And in fact, Scout goes too far as to saying of Judge Sherwood that his credibility determinations were made.
Let me interrupt for a second, because that wasn't actually the argument he seemed to make today. He seemed to be making the argument, and I'd like you to address his argument, that even if you accept all of the testimony that was given and don't make credibility determinations, that you still can't find that Panettone did not act as the investment manager. I think that's the argument he made. So I'd like to hear your response to that.
Surely. Thank you, Your Honor. If you accept all the testimony, it can't be found either by the weight of the evidence standard or the fair interpretation of the evidence standard that Panettone was the investment manager. Now, we must keep in mind here that there are two things that must be shown for this to be a PI program. One, that Panettone provided investment management services that are normally provided by an investment manager. And it must also be true that CalSTRS did not retain and utilize Principal as its investment manager. So even if you found that Panettone, as Mr. Genender urged below, that Panettone was acting as investment manager for the joint venture. He never really argues that Panettone acted as investment manager for the investor who has agreed to be agreed to be CalSTRS. He never argues that. And that's what's in the definition of PI program, where the investor has retained an investment manager. He argues that Panettone acted as if it was the investment manager for the joint ventures. The question under the definition of PI program is, did the investor hire an investment manager? That's the question, and that's what the trial was about. If you accept that Panettone performed services that are like investment management services for the joint venture, that doesn't resolve the issue. If you also must accept, as Judge Sherwood found, that CalSTRS retained and utilizes Principal as its investment manager, on which the evidence was overwhelming. Now, the services that Scout points to that Panettone provided for the joint ventures, which they claim are investment management services, are the same services that Panettone performed for those same properties before PanCal was formed. So the PanCal joint venture, the original joint venture, was formed by Panettone contributing about 67 properties into a joint venture. CalSTRS contributed about $850 million in cash. So Panettone was the seller into the joint venture, Principal contributed the cash, and Panettone had a small minority interest. Panettone was the joint venture operator. It performed services for the joint venture for fees. Now, the properties that were in that joint venture had been previously owned by Panettone. They were in Panettone's own portfolio. Panettone had owned them and been providing services for them for years as JV operator, because each of those properties had been held in small JVs, individual JVs.
Panettone, what did they do? And they had responsibilities for the cash as well, no?
Sure they did. And in those joint ventures, they performed all the services that are needed for those properties, everything from cutting the grass to leasing them up. If they needed debt, they would do that. And Panettone did all those things. And during the trial, as set forth in our brief, Scout's witnesses admitted and agreed that those services that Panettone did when they owned the properties, when they were in the portfolio, those services were not investment management services. And Panettone was not acting as an investment manager then. Of course they weren't. They were the JV operator. And Scout is now arguing that those same services that Panettone performed pre-PanCal for the same properties, now those magically become investment management services. Judge Sherwood didn't accept that. I don't think it washes. Okay, the services are the services. They can't become investment management services just because Panettone sold the properties. And to take to another example of the lack of merit of their position, the first joint venture was formed, as I said, by this Panettone selling properties into the joint venture and Principal and CalSTRS contributing cash. In the negotiations for the formation of that, Principal was right there representing CalSTRS all along. Principal negotiated with Panattoni. Principal decided which properties would go in and which wouldn't, what would be the pricing. All that negotiation took place by Principal. And Principal did all the due diligence on that. At trial, Scout maintained that nonetheless, for the formation of that joint venture, Panattoni was CalSTRS investment manager. And Judge Sherwood at one point said, how could they have been the investment manager? They were the seller. Who did the due diligence on that property? And Mr. Genender, responding to the court, still maintained that in a transaction where Panattoni was the seller, that it also was the investment manager for the buyer. And that's just completely untenable. He claimed that Panattoni was on both sides of the transaction. That shows you how convoluted their theory has been. But get back to the original point. The main issue that was tried was whether Principal is the investment manager for CalSTRS. The court heard days and days of testimony. The witnesses were close by the court. The court was very active, asked a lot of questions, made observations, found Scout's witnesses to be not credible, and credited the testimony of principal witnesses, CalSTRS witnesses, and Panattoni witnesses. And now, Scout is asking this court to throw that all out. And on the central issue of whether Principal is CalSTRS investment manager, Judge Sherwood must be upheld. Now, before the trial, Scout told this court that it was necessary to identify the actual services Principal provides to CalSTRS. That's their wording. That's what happened at the trial. We agree that that was necessary to happen. It happened. The court heard hours of testimony on it. The court believed it. That testimony showed the role of that when properties are to be bought by the joint venture, acquired, what happens is Panattoni identifies a property as maybe useful for this joint venture. It presents it to Principal. Principal then decides whether it's a go or no go initially. If they like it, then they take it over. They do the due diligence on it. They do everything. And they have their own internal evaluation. And if they like it, if they think that this is good, they then present it to CalSTRS and recommend that CalSTRS buy this. Panattoni doesn't even have contact with CalSTRS. They're trying to sell this court that Panattoni is CalSTRS investment manager when Panattoni doesn't even have contact with CalSTRS. In terms of
Counselor, you've already exceeded your time, so I'm going to ask you to wrap up your argument, please.
Okay. Selling properties. The disposition of properties was controlled by Principal. Principal sent Panattoni every year a hold-sell list that told Panattoni which properties should be sold and which properties should be held. And the testimony on that was that Panattoni could ask questions about it, but the decision was Principal's. Principal decided that. And that's part of the Scout says buy, sell, manage. Well, that's sell. Principal determined that. The disposition strategy was controlled by Principal. Manage, every significant thing that happened to these properties was controlled by Principal. Leasing, they had to approve all the leases, the pricing on the leases, what the tenants paid, any significant construction, all of this needed to go through and be approved by Principal. Panattoni didn't even approach CalSTRS on this. It only went through Principal. The evidence is overwhelming that CalSTRS used Principal as its investment manager, Your Honor.
Thank you. Rebuttal?
Thank you, Your Honor. I was muted. May it please the court. Mr. O'Connor 5 times in his argument presented the wrong question to this court. The issue is not who was the investment manager for CalSTRS. The issue was Principal engaged and retained with respect to the investment? And you didn't hear a peep from Mr. O'Connor about any contractual authority that Principal had with respect to capital or assets of the investment. I believe he misspoke when he said Principal contributed capital. Principal had nothing to do with the money. When you're talking about investment management, you've got to follow the money. Principal was an advisor and a consultant. Under Section 14.01 of these operating agreements, CalSTRS, who has a staff of 21, is what Mike DeRate said, has designated Principal as an advisor and its lawyers as being authorized to communicate what CalSTRS wants to do. What Mr. O'Connor was saying, Principal decides, that's not right. CalSTRS ultimately is the chief engineer of the train. That is what Judge Sherwood asked of Bill Bullen in his testimony, and Mr. Bullen agreed. But they can't be communicating with all of the hundreds of different managers they have out there for their different properties. They don't have enough staff. So they use an advisor, a consultant, to help them oversee. But there is no way in which Principal can be deemed to be managing something with which it has no contractual connection. They're not a member of any of these LLCs. They admit they can't bind them. They have no right to insist on participating on the management committee. All of the active management, and if there's one exhibit that I'd ask you to look at, it's the Hayne-Hamilton memo. That's exhibit 36 in volume 6 of the record. Whether they were doing similar services before, that's not what we're talking about here. Cutting the grass and painting, those aren't investment management services. Panattoni was contractually obligated to do business plans, to do wholesale analyses. Before, they didn't have a portfolio. They had a bunch of individual assets. Afterwards, they did portfolio management pursuant to these contracts. Principal, as a stranger to these contracts, who's only authorized really to be a mouthpiece for CalSTRS, isn't actively managing. Management is active. What Principal was doing was reactive, helping CalSTRS exercise its rights as the investor. But CalSTRS is not self-managed. They can't be by policy. That's exhibit 13 in the record. So they hire other people to buy, sell, and manage. Mr. Duray actually testified to that. Principal, with respect to these investments, has no authority over the day-to-day management. Mr. Bellecci testified to that in testimony that's undisputed. Day-to-day management is done by the manager of these LLCs, of these joint ventures, and that is Panattoni.
Okay, Counselor. Thank you.
Thank you. Thank you, everyone. Stay safe.
You too. All right, the next case is Sandy versus Trinity Center. And if you'd give me just a moment to set up. Okay, Mr. Baker, you can proceed.
Thank you, Your Honor. Good afternoon, fellow counsel, members of the court. May it please the court.
Can you fix your mic? You muted, Mr. Baker? We can't hear you or see you.
Okay, hang on 1 second.
Yes, we can.
Hang on. Somebody please get the fuck in here and help me.
I just want to make sure. Can you hear me? Okay.
Yes.
Your Honor, can you see me now?
Barely. We can't see you though, Mr. Baker.
Can you hear me?
Barely. If you could keep your voice up, I think we
I will
could
do
proceed.
the best I can, Your Honor. I apologize.
You don't have to apologize. We're all getting used to different technical skills that we never knew we had. Right? All right.
I'm the old dog that can't learn the new trick yet, Your Honor.
Oh, I don't believe
it. Your Honor, then let me get to the gist of my argument, and I'll be happy to answer any questions, and I'll fill in on rebuttal.
Sure, thank you.
On behalf of the appellants, we respectfully submit that the court below committed error in denying the motion for summary judgment on the cause of action pursuant to Labor Law 241-6, when the court held that 23-1.7E2 was not applicable to support a Labor Law 241-6 claim. The unrefuted testimony in this case, the unrefuted evidence, is that Mr. Sandy tripped over a floor box, which was raised above the concrete slab when the existing floor was removed during the demolition part of the job that was run by Tricon. It was covered by a pile of debris. So Mr. Sandy could not see the floor box and tripped over it while attempting to push the pile of debris out of the way with his foot. The facts of this case and the rationale are identical to the holding of this court in the decision of Licata versus A.B. Green Gansvort, which this court decided in 2018, where it specifically held in that case where a pile of debris prevented the plaintiff from seeing a hole which he stepped in. The regulation is applicable. That rationale is clearly applicable under the facts of this case, and failed to apply the precedent set by this court. So I believe the decision insofar as he said 23-1.7E2 was not applicable because the plaintiff didn't trip over the debris. Instead, he tripped on the floor box. I believe that was error, and summary judgment should have been granted to the plaintiff on that claim. I will tell the court that in preparing for this argument, I've done a lot of soul searching regarding the 3.3 claim, and I think that part of the decision the court below may have actually gotten correct, so I'm not pursuing that. However, I do believe that the court also misapplied the law in denying our claim pursuant to Labor Law 200, because the court again focused solely on the pile of debris and not on the raised floor box. Clearly, Tricon, as the general contractor, which was hired to do demolition as part of this job, knew or should have known that once the existing floor was removed, these raised floor boxes were going to be protruding above the slab, thereby becoming potential tripping.
Counsel, aren't these arguments inconsistent that you're making? For one argument, you're arguing that the cause of the accident was the pile of debris, which is why the 241-6 claim should survive. And then for the common law negligence, you're making the opposite argument, that it was really the electrical box which caused the injury rather than the pile of debris. Isn't that inconsistent?
I don't think it's inconsistent, Your Honor. You know, what I think the court below did is you're separating the two conditions that contributed to this accident as separate and distinct conditions. The two have to be looked at together. The floor box standing alone, my client would have been able to see. Once it's covered with a pile of debris, he can no longer see it, and it becomes a tripping hazard when he attempts to push the debris out of the way with his foot.
So, counsel, if there's no notice, if there's no proof that they had notice of the debris, how do you get around that with respect to a 200 claim?
I'm glad you asked me that, Your Honor, and I want to address that. The general contractor, this is a one-story structure. It's a store. It's not a 20-story project. They had a project manager who was on site on a daily basis. And I know that that fact standing alone doesn't get me over the notice hurdle. But clearly, the general contractor is on notice that the existing floor was going to be removed and that floor boxes were to remain according to their own blueprints. So they knew there were going to be raised floor boxes.
But aren't the boxes only a danger if the debris is there?
But, Your Honor, this general contractor deliberately chose not to have, they had primary responsibility for housekeeping and debris removal. They deliberately chose not to have a laborer on site on a daily basis.
We attached the daily logs for the period from, I believe, December 16th through January 13th. That's 14 work days where there were people on site, and yet this general contractor chose only to have a laborer on site on 2 of those occasions. There are no daily logs produced from January 13th up through and including the date of accident. However, Mr. Sandy testified that he was on this job site for approximately 2 to 3 days before his accident. During that time, he said there were piles of debris all around the job site. The room where he was working in had a pile of chopped concrete debris that he had to step over, in addition to the offending pile of debris that hid the floor box. During those
counsel, if I may, this is Justice Kennedy, because there's also evidence in the record that the plaintiff testified that he did not know how long the pile of debris was present, how it got there. There were no complaints made about the pile. So the record is absent of any evidence regarding how long the debris was present.
Your Honor, the plaintiff was specifically asked at his deposition, were there other piles of debris within a 50-foot radius of where you were working? And he said there were piles of debris all over the floor.
For how long? For how long? What was the length of time? Because I don't recall seeing that. How long?
I hear what you're saying, Judge, but you have to look at it in the context of during the period of time he was on this job site.
Right. No, I understand that, but how long? What is the length of time? Because I don't recall seeing it.
Job for 2 to 3 days, and during that time, he didn't see anybody picking up debris, and he didn't see anybody using the containers, which were all up by the Broadway side of this job site, by the front of the job site. And also, Your Honor, they're on notice that there were floor boxes on the concrete slab located throughout the job site. Okay, so I respectfully submit the general contractor is negligent for not having those guarded or marked, and he's negligent for allowing somebody to put a pile of debris on it. How can you argue that this box is not a sharp projection within the meaning of 23-1.7E2 when it's clearly defined and it's within this court's rationale in the Leonard case, which was in 1996. They specifically referenced Webster's dictionary in defining what the word sharp meant, and it says clearly defined and distinct. This was a 4-inch by 4-inch metal box protruding 2 inches above the floor. How does this thing not get defined as distinct and clearly defined within the meaning of that regulation, which is defined more broadly than the preceding paragraph, because the words cut and puncture don't appear in E2, whereas they do appear in E1.
All right, Mr. Baker, we'll hear from your adversary at this point. Ms. Kaczynski?
May I please the court? My name is Abby Kaczynski, and I represent the respondents. I think Justice Kern and Justice Kennedy hit it right on the head. This is not the defendants moving for summary judgment. This is the plaintiff moving for summary judgment. And the burden of proof is the same, irrespective of which party moved. The plaintiff had the burden of proof to show that as a matter of law, the general contractor, Tricon, because I think the owners, it's clear that they weren't on site. But anyway, as a general proposition, that we, as a matter of law, breached a duty with respect to the talk about the 200 claim. Now, the burden is on the plaintiff at this point. It's clear, and I have to concede, we're the general contractor, but that's not enough. It's never enough. We do, as Justice Kennedy said, what and how did these debris piles become present? I think the lower court should be affirmed because they actually hit the nail on the head with the issues. Plaintiff had the burden as a matter of law to show that these piles existed for such a length of time that the GC, meaning Tricon, could have cleaned them up. Whether or not there were other piles in other areas is not of import. The case law is clear. It's that specific defect, those at the time. It's not about what a general condition is. So if we focus on that room, the plaintiff got there that morning and this is what he saw. And
Counsel, I'm going to interrupt for a minute and ask you a question about the 241-6 claim and why the plaintiff shouldn't get summary judgment on that claim. If going back to my question before about the claims being inconsistent, if the real claim is that the injury producing object was the debris rather than the electrical box, why wouldn't there be a viable 241-6 claim based on Industrial Code 23-17E2?
We would argue that the electrical boxes are quite possibly an integral part of the work, which then begs the question of whether or not what he actually fell over. Without looking at the plaintiff, he describes two different defects. The possibility that debris was over this box, and then that he definitely tripped over the box. We feel that we raised issues of fact as to what exactly was going on with the conditions in that room immediately prior to his accident. Whether or not
did you raise a disputed issue of fact as to whether he testified there was debris in the floor and it was a debris that caused him to trip? Did you raise an issue of fact with respect to the existence of the debris on the floor through any of your witnesses or testimony?
Respectfully, he did not testify he fell over debris. He says that the debris possibly was covering a box. He does not
possibly, or he said it was concealing the box. That's what he said.
Doesn't know. He says he's moving. As the plaintiff himself said, he's moving debris. He's not sure where the box was or when it was when he got into the room. He sees debris. He never says he sees piles exactly over the box. The debris is eventually
because the concept is that the debris is concealing whatever is beyond it that he tripped over. And that's actionable, assuming that he can prove that, right? We don't dispute that a debris claim under 241-6 can be that it's concealing stuff that it shouldn't be there, and it's concealing something that you would otherwise see and avoid tripping over.
Well, that I think we've answered the question. If we keep asking ourselves these questions about where the debris is, how it came to be, is it covering the box? He is not. If you read his testimony clearly,
asking those questions. Yeah. You said we're asking ourselves questions. Maybe there are some questions of law, but questions of fact, you have to create them.
What I'm trying to say is we do not know for certain that the debris was originally covering the box.
Well, Counselor, if I may, I would like to address this since we're talking about the debris. It was clearly not an integral part of the work. Is that correct?
Itself, I agree. Absolutely. No. Debris from HVAC, no, absolutely not.
All right, so let's just follow this track. So since we agree that the debris was not an integral part of the work and that he trips over debris, which covers the box, licata applies, correct?
We would still argue that there's still questions.
That's either a yes or a no. Which one is it?
Yes. Okay. But there are questions raised about the proximate cause of his accident. Our argument as to why there's an issue of fact is what exactly caused him to fall. Was it the he does not?
Excuse me, Counselor. You seem to think that there's a question of fact about that. It seemed to me that he was pretty clear about that. And frankly, I don't see what question of fact you have raised about that being the cause of his accident. And in the absence of a question of fact about that, it seems to me licata, which I sat on, governs. So what is the question of fact?
When there's a violation.
Let me just be more clear. It seems to me he's clear that he was backing up to kick the debris out of his way and tripped over something obscured by the debris. What is the question of fact about that?
Your Honor, if we want to discuss what you just said that he was kicking debris back. If he's kicking debris back, which is part of the plaintiff's argument that should not be considered, then the fact of the matter is we do not know which came first, him pushing it back or the debris over it first. and I really don't want to talk about what he was doing because that's part of the argument was that the judge was not focused on that. But when you look at the facts of the case, we are talking about which came first, the debris over the box or whether or not he just tripped over the box and did it himself. So to say that the debris was covering that box before his accident, we say there's a question of fact about when and how that debris came over the box, which would then arguably make a question of fact about whether or not the 1.7E2 was violated. Secondarily, whether or not it's a proximate cause of the accident, separate issue. But whether or not there's a predicate, we believe there's a question of fact about which came first, that debris over the box before he got into that room or after he was already in that room. And that should be sent to a jury, whether or not 1.7E2 is a predicate. The secondary issue about proximate cause should go to a jury anyway. That's my argument to you.
Because the trial judge indicated, the motion court indicated that while he was walking backward, his right foot got stuck on something that was under the debris. So what did you present to raise an issue of fact regarding this? Because what happened was his right foot got caught on something and then he fell. The debris was covering it. So what evidence did you present to counteract that?
Well, in the first instance, we also argued that the plaintiff didn't make his prima facie case that it was violated. But if we presume that you found that the plaintiff makes a prima facie case, the fact that he's tripping and then looks after to see what debris is on it is a question of fact as to when that debris got over the box. Whether or not you agree or not, I respectfully say that is a question of fact to find out when that debris came over the box. Was it before he was in the room and already there? Then you possibly are right that it's a predicate. But if we do not know for 200 purposes when that debris came into the room, then consistently, how do you know when and how that debris came over the box? And if it wasn't over the box at the time, we argue it's an integral part.
You don't need to know when for 241-6, right? Okay.
Yes.
That was just for notice purposes that we were talking about the 200, which is a fair issue there. All right. Okay. I think we understand your arguments. Let's hear some rebuttal from Mr. Baker.
Very, very briefly, Your Honors, and again, thank you for the opportunity on rebuttal. I think the questions that were posed to my colleague hit the nail right on the head. Under the Court of Appeals decision in Rizzuto, Labor Law 241-6 is a statute that imposes non-delegable duties on these defendants. I'm not required to show notice, and I'm not required to show direction, supervision, and control. The plaintiff.
No, but her point was somewhat different, which is that if the underpinning of your claim is that debris was covering the box, and that's what caused the fall, did you show that the debris covered the box before he fell, as opposed to?
If you look at the plaintiff's testimony, he came in and he described a pile of debris. When he attempted to push the pile of debris out of the way, his right foot came into contact with something. He was asked directly at his deposition, why didn't you see the box? His answer was because the debris was covering it. He was then later asked, his testimony is, as he's laying on the floor, his helper went to get the foreman. When the foreman came in, the foreman asked him what happened, and he said, I'm trying to move the debris out of the way, and I hit something. And at that point, he says the foreman moves the pile of debris, at which point the plaintiff sees the box. He's then asked, how do you know the box caused you to trip? He said, because there was nothing else there other than this box once the pile of debris was moved out of the way. And it's clear from the testimony and the construction drawings that floor boxes were to remain in place as part of this job site. So I think it's pretty clearly established that the facts of this case are right on point with this court's decision in Licata, and plaintiff should have been granted summary judgment on the 241-6 claim based on 23-1.7E2.
Okay, thank you. Thank you both.
Thank you.
All right, the next case is Roa versus City of New York. You can proceed.
Good afternoon, Your Honors. Chris Savro, Paul Isaac, and DeSico on behalf of the plaintiff appellant. I was having a little technical difficulties before. Let me know if I break up or anything. Otherwise, I'll just jump right in.
You will. Go ahead. Yeah.
Thank you.
It's our new reality. Go ahead.
Indeed. As we set forth extensively in our brief and our reply brief, there's really only one issue that's properly before the court, and that is whether or not Con Edison was liable as a matter of law for its failure to adhere to its own respective duty of maintenance. Now, I think that there's really three salient facts that we should dive into first that show that the plaintiff carried his prima facie burden and Con Ed failed to raise any triable issue of fact. And the first is that when faced with a notice to admit regarding its duties of maintenance and control, Con Edison admitted that it maintained and controlled the vault, but denied everything else. Well, the notice to admit was at 265 to 266. And the pertinent point is that number 6 was, did they have a duty to periodically inspect? Con Edison denied it. Now, the proof that they submitted bears out the fact that they failed in any way, shape, or form to actually substantiate that they had a periodic inspection in place. Now, they cite to a public service commission law that establishes that every 5 years, at least every 5 years is the quote, they're required to inspect the vaulting for stray voltage. And if you look to the genesis of this public provision as the New York state law, it's because a pedestrian walking by a vault was electrocuted and died. It had nothing to pertain with the actual grading and the sidewalk around it. So the issue before the court is the fact that our expert opined that it's good practices to inspect at least annually. And there's nothing to the effect that they ever even came close to doing this. This is exactly what our expert testified. Now, very recently, and I think this is a good opportunity for the court to nip something in the bud. The New York State Supreme Court, the County of New York, dealt with this in Koff versus Marty-Salgado. That's 2020 New York Miss Lexus 4261. The decision came out August 11th, 2020. And in that case, Con Ed, again, relied upon Mr. Pinnick, who conducted an inspection 44 months in advance. And the New York County Supreme Court held that his testimony was insufficient to carry the burden to establish a reasonable inspection, that it was too remote in time, and that it was unrebutted that plaintiff's expert established that it should be an annual inspection. Now, this court in a case relied upon by Con Ed, which was the DeSanza versus City case, 4783rd 535, that was decided in 2008, the dissent had very significant concerns with Con Edison's position that they're advancing now as well, that there is a substantial conflict. In DeSanza, they even had as an internal mechanism that they were supposed to yearly inspect their vaults. But the dissent noted that this is in conflict with the provision of 34 RCNY 2-07 sub B and what constitutes a reasonable inspection, raising even the question of whether they should be doing more than their own internal guidance. Now, the other thing that needs to be noted is that if they were truly inspecting each vault and every aspect of it every 5 years, then at some point between 2009 and 2014, this vault would have been inspected. Pinnick clearly missed that there is a substantial defect already in place. The unrebutted photographic evidence shows that this defect existed since at least 2011. There's nothing in evidence about when their prior inspection took place, if they even adhered to their alleged 5-year standard that there's urging the court to adopt, which we submit is unreasonable now as a matter of law. There's still no proof that they ever inspected it within any modicum of time close to this accident. I'm happy to address any of the other points, Your Honor, but I think that's the thrust of this case. I know that both Con Edison and Abner put forward some arguments about whether or not one or the other should be solely liable. It's our position that neither of those issues are preserved. And I'm happy to address those if you have any questions, but otherwise I recognize that it's late in the day and I don't want to take up too much of your time.
Thank you. All right, we'll hear from Con Ed first. Con Ed?
Good afternoon, Your Honors. Stephen Brewery for Con Edison. Can you see and hear me?
Yes, we can.
Okay, terrific. Thank you. All right, first, I just want to address the 2011 Google image that plaintiff's alleged expert, Mr. Silberman, claims identifies a defect. It's Con Edison's position that Google image does not, you cannot tell from that Google image whether there is a lift or defect within the sidewalk flags at the location where the expert circled on the Google map. Even looking at, the photograph itself that's in the record is way too small, it's grainy, etc. And I also went on the website, which, Plaintiff's Counsel invited Your Honors to do. And if you look at it still, when you go to the image, you still can't tell if there was a defect at that time. Therefore, plaintiff's repeated statements that there's unrefuted evidence of a defect in 2011 falls flat. I believe that Mr. Pinnock's examination of the vault I think it was less than 23 months before plaintiff's accident. He conducted an investigation and an inspection of the entire vault, including the exterior. And when he was done, he did not notice any tripping hazards surrounding the grating. So therefore, Con Edison, based on his testimony, Con Edison was not on actual notice at the time of the plaintiff's accident. And also, and there was also no constructive
Counsel,
notice.
if I may, I'd like to go back. What
Certainly.
evidence did you present to indicate that you conducted repairs or did inspections from 2014 after the inspection until the date of the accident? What, if any, evidence did you present regarding further inspections?
The only evidence Con Edison presented on this motion, Your Honor, in opposition to plaintiff's summary judgment motion was Mr. Pinnock's affidavit, because he was the last person, as far as Con Edison is aware, that conducted an inspection of this vault grating prior to plaintiff's accident.
All right, let's go back further. So 2011, what, if any, evidence did you present to refute that the defect existed since 2011? What, if any, evidence did you present to contradict that?
What, I'm not following you, but it's just that there was nothing. I mean, the opposition was that photograph.
Counsel, let me repeat myself.
Right.
I want to make sure that you understand.
Okay.
Because I think it's very persuasive that there was evidence that a defect existed in 2011. So my question is, what evidence did you present to raise an issue of fact regarding that?
The evidence that we didn't present any other evidence going back to 2011 after he presented that photograph. Instead, the argument was that the photograph doesn't depict anything, that the burden is on plaintiff to show that photograph actually shows a defect, and it did not. So that's Con Edison's argument as to that point, that photograph does not definitively show a defect. It is blurry, it is grainy, and it is unclear. So this is supposed to be an expert who should have, and he's making a presumption or an allegation that doesn't seem to be supported by his own photo.
Thank you, Counsel.
Okay. And so, so the point is that once Mr. Pinnock raised the fact that he conducted an inspection, in support of that, also that not being aware of a defect at the time is also subsequent to his inspection and prior to plaintiff's accident. Both plaintiff and Mr. Koppel, who is the abutting property owner's managing agent, had passed over this area numerous times And neither one of them had ever noticed this defect before. So that also supports the fact that Mr. Pinnock didn't just, miss something. It's just that it might have been something that didn't exist. Or it's just like the specter of the patchwork. I know that Abner Properties doesn't want me to talk about it, and plaintiff for some reason thinks that this isn't properly before the court, but it is. It's just that the plaintiff talked about when she exited the subway, the sidewalk was all broken up. Mr. Koppel testified at his deposition that he had discussions with his superintendent about the use of patchwork to repair any defects within the sidewalk. And although he couldn't recall whether or not he had that before or after the accident, but be that as it may, if you look at Exhibit D, which is what plaintiffs identified at her deposition as having her daughter having taken just right after the accident, she circled the area where the defect was, and within that photograph, there's evidence of patchwork. And so, it's just that, was that patchwork there when Mr. Pinnock arrived? Because, the patchwork seemed to confuse Stanley Fine. Stanley Fine, when he investigated the accident location, his affidavit or his report, he said that the defect had been repaired 1 year after the incident. But yet Mr. Silberman, when he went and inspected the area over 2 years after the accident, he said the defect hadn't been repaired. So, it's just like there's all this confusion by plaintiff's experts about was it repaired, wasn't it repaired? Is the use of patchwork proper or improper? According to Mr. Silberman, you never do that. That's, against the city code and rules and regulations, that it's an improper repair. So if that's an improper repair, how can Con Ed, who needs to, when you repair, as Mr. Silberman pointed out, if you have to repair a sidewalk flag, you have to repair the entire flag. Well, if you look at Exhibit D again, you will see that there's a scaffolding extension right in the middle of that flag, which would have to be excavated. And even Mr. Koppel acknowledged at his deposition that Con Edison or anyone could not safely excavate and replace that sidewalk flag without undermining the safety of the scaffolding. So, and also in plaintiff...
I'm going to ask you, Mr. Brewer, you need to finish up.
I'm sorry, I'm on a roll. I was
Yeah,
heading down.
a roll right past your time limits. Go ahead.
Well, it's just that I'm sorry if I could just say one more thing if I'm passing my time limits. It's in plaintiff's...
You're way past already, so...
I apologize, Your Honor. Just in plaintiff's reply brief on page 17, there's a statement that says, regardless, there are issues of fact as to the degree of access to which the scaffolding still allowed Con Edison to make repairs. So even plaintiff acknowledges that the scaffolding created a problem for Con Edison, and it raised an issue of fact as to whether or not they could actually make the repairs with the scaffolding in place. Thank you for allowing me to just spew that out, and I apologize for speaking
No apology necessary. All right, Abner Property.
May it please the court, Your Honor, I will try and be very brief. If you look at plaintiff's original motion, it was made against Con Ed as the owner of the area within 12 inches of the grate. So I'm going to speak very, very succinctly on that. As I'm sure Your Honors know, any defect that occurs within 12 inches is Con Ed's ownership of that property. No one disputes that the incident occurs within 12 inches of the grate. So therefore, it's Con Ed. So I joined plaintiff in agreeing that Con Ed owns that area. They're responsible to maintain that area. They didn't inspect it. With respect to any allegation about Abner Properties, Mr. Brewer admits he didn't want to bring it up. There's no testimony by anyone that concretely establishes that Abner repaired the area, did the area. In fact, the testimony
let me ask you a question. What about the issue of the scaffolding? Aren't there claims that your client put up the scaffolding? That seems clear, right?
I believe he did.
They were doing construction, right? So
they were doing local 11 lawyers.
Okay, right, there's scaffolding. To the extent that Con Ed claims that your scaffolding prevented them from fulfilling their obligation, does that keep you in the case?
I would say no, Your Honor.
Why not?
Well, for the simple reason that there's no evidence that Con Ed ever reached out to Abner Properties claiming that the scaffold prevented them from doing their duties. There's no evidence that they ever contacted Abner to say, we need to repair the sidewalk flag. Your scaffolding's impeding it. They made no efforts to contact us and put us on notice that the scaffolding was impeding us from inspecting their property. Plaintiffs established that there was no inspection to the area, so Abner can't be held responsible for something that they weren't made aware of without any affirmative action of Con Ed to say, hey, Abner, your scaffold's blocking us. We need access. You need to move it. Does that answer your question, Your Honor?
I have to think about it.
So if there had been some affirmative action on Con Ed, then I would agree with Your Honor that yes, if they're in theory, or impossibly in theory, if there had been some action where they had done an inspection, had noticed a defect that was theirs, which I believe it is based upon the regulations, and said, we need to repair our defect, your scaffold prevents us from that, and we didn't answer an email or a letter or a notice, then I believe Your Honor would have an argument that Abner could be held responsible. But because they didn't do that, then I don't believe we can be held responsible. And respect, and then I'll wrap it up because I'm sure I'm very close to my time.
You're past your time. Everybody is today.
Everybody is.
So, right. So that's because I'm not good at keeping time on my phone. So here's my question. Do you agree with Con Ed that the 2011 Google image doesn't show a defect?
I honestly, I don't think there was the 2011 Google image doesn't show a defect. I think to the extent that a defect exists, it's on Con Ed's grate within 12 inches of their property, and thus they're responsible for it. I believe.
But you don't take a position about whether there is a defect at all?
I don't, Your Honor.
Okay. All right. Understood. All right. Thank you. All right. Plaintiff, your rebuttal.
Okay. I'm going to try and address 4 points at light speed. And the first point is that what Abner just discussed and what Con Ed discussed about what's before the court is not accurate as to what our position was. Our position is that neither one of them can seek to have a finding of sole liability against the other. Abner never moved for that relief below. They never advanced an appeal on this. Con Ed never appealed its denial of summary judgment. It's well established under.
And you solely moved for summary judgment against Con Edison. End of story.
Exactly. All right, so I'll move on from that. And the second point would be related to Abner's argument is that they can't just simply ignore the special use and assumption of a duty. There's testimony by their client that raises a clear issue of fact as to whether or not they put in flash patching. Con Ed denies it. It was very smart of plaintiff not to move for summary judgment. Clear issue of fact. On a related note, what Con Ed said, he took our words out of context on page 17 of the reply. We didn't admit that there's issues of fact that would entitle them to a trial. We said that there's issues of fact about what they should have done when the scaffolding was put up. They could still have barricaded the area. They just never came back to inspect it. And that carries the whole theory of liability. The other thing is Con Ed can't ignore the fact that the Google images conclusively established that no scaffolding was in place. There's no clear testimony as to when it was put up, and had they done their reasonable inspections.
But the Google images were taken in 2011, right?
Right. And
right. So the scaffolding, why does that have bearing except at the time that she is involved in the accident?
Well, it has bearing to Con Ed's position that they couldn't have possibly done anything to rectify the condition. They can't even establish when the scaffolding was in place that allegedly precluded them from taking any actions. And it's not like Mr. Pinnick said that he had trouble accessing the site in 2014. To the contrary, he said he went down and everything was great. And he was able to do his full inspection, which allegedly included an inspection of the grading as well. Although that's not noted in his notes on page 662 of the record. Nothing is mentioned about any grading inspection.
Do you happen to have the page number that the Google image is on in the record?
Yes, I do. It is on pages 565 through 566.
Thank you. Go ahead.
And the last, if I can indulge one last point.
One last point.
Even if we ignore the 2011 Google images, the DeSanza case that Con Ed wants to rely upon wants to say that a 5-month period in between an inspection and the accident is reasonable. Here, they admit that there is 22 to 23 months intervening. By no concept of the law is that constitute reasonable conduct. Thank you, Your Honors. Be safe.
Thank you. Thank
Thank
you.
you, everyone. Be safe.
Same to council. All right. Fuller against KFG Land.
Good afternoon, Your Honors. My name is Seth Weinberg. I represent KFG Land. And I'd like to begin by just resting on our briefs with regard to the common law negligence arguments, because plaintiff didn't respond to any of our arguments in their respondents' briefs or the summary judgment motion below with regard to things such as out of possession, ownership, and the not knowing of the cause of the accident. Instead, I would like to begin with the issue of the workers' compensation defense. And whether we apply it to 240 or the remaining negligence claims, that defense would wipe out everything here. And the reason for that is these defendants are an integrated entity. Yes, Your Honor. Justice Gesper, did you have a question? I apologize.
I just took a breath.
Okay. So all of these three entities exist together to operate a nursing home. They were set up for that sole purpose. They are regulated by the Department of Health. Certainly, the parent company is.
But KFG Land is not regulated by the Department of Health, right?
Correct, but KFG operating, and more importantly, Venture Hopkins.
But Venture Hopkins is not a party to this issue. The only issue here is whether KFG Land is liable, not the parent company. So let's stick to those two companies, because those are really only, here we have two sister companies. And that's the issue here. There's no question that Hopkins is the parent company to both.
Well, yes, Your Honor, but the point is Hopkins dominates both together to make them one entity. So I don't think you can completely ignore Hopkins to the extent that if you do that.
Establish that they're integrated entities, you have to establish the relationship between those two. So could you explain to me how you do that?
We do that by pointing out, for example, acknowledged in the lease agreement. They were formed for the purposes, the half you need to operate a nursing home. One needs to own the building and one needs to operate the assets.
I understand that one owns the building and the other one operates the nursing home. But that in itself, and the fact that they're owned by the same parent company, is not sufficient, as I understand it, to establish a lack of liability for KFG Land, excuse me, under the workers' comp law. For example, so what are the other factors that you consider important?
So, for example, that they file tax returns through Hopkins Ventures.
I was hoping you would raise that. I saw you raise that. You argued that in your brief. Mr. Gross says it in his affidavit. But oddly enough, Mr. Gross doesn't attach a copy of the tax returns to the affidavit. Obviously, his statement as to what's in the tax statements is not good evidence on a motion for summary judgment. And I looked and looked, and I didn't see that he had attached the tax document himself. However, plaintiff attached the tax return in the form apparently given to them by KFG Land. And what they had was only Hopkins tax return, which makes no mention of either KFG Land or KFG Operating. So I don't see how that document, which was not proffered by your client at all, first of all, how we can rely on Mr. Gross's statement about it, since he doesn't attach the tax return at all. And then the tax return that's presented by plaintiff makes no mention of either KFG Land or KFG Operating. So how does it help you?
Well, again, Your Honor, we would rely on Mr. Gross' testimony. If that's not sufficient, then we can't rely upon it. If the court finds it's not sufficient.
When you say testimony, you mean the affidavit, correct?
I believe it was his affidavit, Your
Right,
Honor.
you put in an affidavit. So one of the things he talks about the tax returns is that he said that all three entities have the same tax ID number, correct?
That was his statement, yes, Your Honor.
Right, and we don't have anything disputing that, do we?
No, we don't.
And even the tax return isn't inconsistent. That was put in by the other side isn't inconsistent with his statement that they file one tax return under the Hopkins Ventures for all of the entities. Is it?
That's my reading of the tax return, Your Honor.
Counsel, you didn't produce any documents to show that they have, either that they filed the same tax return or that they have the same tax ID number.
Well, Your Honor, again, it's our position that
Were there
we did
any?
not attach the documents.
Okay, and you rely a lot on the Canty case, I believe it is, where there was one of the factors there was joint financial management. All that I saw about financial management was that the KFG Land and KFG Operating have bank accounts, separate bank accounts, and in different banks. What documentation do you present or specific evidence that they shared joint financial management? Was there, for example, a joint financial statement as appeared in some of the other cases that you cite?
Well, with regard to the joint financial statements, we have Mr. Groh's testimony. With regard to Cardi, however, that's the direct answer to your question, Your Honor.
I appreciate your candor, counsel. Thank you.
Yeah. But with regard to the Cardi case, in that case, they pointed out that the operating entity was the one who wrote the checks, which makes sense. That's the one that has employees. That's the one that pays the bills.
Does land have employees?
No, neither Land nor Ventures have employees.
Is that in the record at all, though?
That's Mr. Groh's testimony. There are no employees. That the only entity that has employees is operating, which makes sense because Land's sole purpose for being is to hold the deed to the property. You don't need employees to function in that regard.
But Canty also said they had joint insurance policies. I didn't see any jointly held insurance policies in this case. Certainly KFG Land would have insurance for the land, but there's no evidence in the record that they held joint insurance policies. Is there?
No, Your Honor, but I would point out that with regard to the focus below.
And Canty, correct?
I'm sorry, Your Honor, you cut out. I didn't hear.
Factor that's raised in Canty that you don't have here.
That is a factor, but the way I read Canty was the primary focus was on the workers' compensation coverage.
I didn't see that. That's actually not in the language of the decision at all that I saw.
Then I must have misread it.
That against counsel.
But my recollection.
This was summary judgment, though, right?
Correct. And so
discovery had been completed? Discovery
had been completed. We were well on our way. And the only claims that remains today is negligence. If the court has no other questions on single entity, I would just move on to the 240.
All right, and I will just indicate that we're also out of time, so I'll give you an additional couple of minutes to address your direct negligence claims, and then we'll hear from your adversary. Right.
Okay, so with regard to direct negligence, there's no evidence as to the cause of plaintiff's fall. We don't know why he fell. His coworker didn't see him fall. Doesn't know why he fell. Plaintiff doesn't know why he fell. And to the extent KFG Land is in the case, if we're not going to treat them as separate entities, then KFG Land is an out-of-possession landlord under the lease, and there's no allegation of a structural defect or statutory violation such as to make them liable under a negligence theory. So I'll save the 240 issues for rebuttal with the court's permission.
Okay, that's fine. All right. Mr. Eckert, go ahead. You're on mute. Unmute yourself.
You're still on mute.
Can you hear me now, Your Honor?
Barely. We do have.
Let me know if I'm shouting.
You're clearly not shouting. We can barely hear you.
May it please the court. My name is George Ilkert. Good afternoon. I'll try and be brief as possible.
Okay, thank you.
No way for the court below to be able to grant them summary judgment on the workers' compensation defense by the proof adduced below. For the reasons stated by Justice Gessmer before, and the separate bank accounts. And I think on the tax return, there's not even a tax ID number on it on the tax return that was produced, and everything else is blanked out. There's also a lease between Land, the direct defendant in this case, and Operating, for the premises, and it recites that it's being passed back and forth. There's nothing to show that it's being operated as a single entity at all in this case.
Was there discovery on this issue?
Yes, they produced nothing other than that. He says that he ultimately he doesn't know that there's a bank account for land, or that there's one for Wells Fargo, or that Ventures. He doesn't know if Ventures has a bank account.
Counsel, did you request the insurance policies for the 3 companies in your discovery?
We can't hear you.
Yes.
And what did you get?
We got the insurance policies for that showed the workers' comp, the KFC operating, and the liability. They don't share. They don't share any. They're not named insureds. All 3 companies are not named insureds on any of the policies.
And did you produce all of those policies in opposition on this motion?
It's they were marked as exhibits, and I believe
At what?
that should be in the record at the examination before trial, and about it, and I think search the record. Testimony in the deposition of Mr. Gross about a policy by Alliance National Insurance Company for KFG operating, which I believe is the workers' comp.
And was that for only one of the entities?
Yes, just for KFG operating.
And what about liability insurance?
The liability
Counsel, they didn't need workers' comp though, right? They didn't have employees.
and
Is the workers' comp policy in the record on appeal? I can't hear you. What?
I'm scanning the record right now for that. I just see the testimony about it in Mr. Gross's.
You mean his deposition is attached, but the policy is not there.
I don't see the policy.
So you didn't attach exhibits from the deposition? Is that what you're telling us?
I don't see them.
But you had them. You didn't put them in opposition?
I would think if it's not in the record, they wouldn't have been put in opposition.
I don't know what that means. I'm asking you, were they in the record?
No, they're not in the record, Your Honor.
So I feel like we're arguing about facts that just, you folks may know them, but they're not in our record. You know, so the question is really whether Mr. Gross's affidavit is sufficient for a prima facie case, and what did you put in opposition to raise an issue of fact, if it was?
The issue of fact with regards to workers' compensation is...
Yeah. I'm having trouble hearing you, Mr. Ilker. Sorry.
They were managed together, or that they had day-to-day oversight over KFG operating, the employer, which they clearly didn't. Mr. Gross says he had nothing to do with the day-to-day management of it or anything else.
Of which company? Of both companies?
Of operating.
Okay. And who did he testify, if anyone, had control over the day-to-day management of KFG land?
The only person I see designated for KFG land was Esther Traub, initially when the lease was signed. That's who signed the lease on behalf of, as a member of KFG Land 1.
right, anything further?
Yes, with regards to the labor law section 240 claim of the plaintiff, he's working at a height of 6 to 7 feet from a catwalk, which is unguarded, no guardrail, no fall arresting devices provided to him. He's installing multiple panels which had previously been removed by a contractor. Household staff basically does mopping and ordinary maintenance. He wears clogs to do that work. On this day, he sent up a 6 to 7 foot high fixed ladder to go on an unguarded catwalk. And while he's trying to install one of the panels, which he had to cut with a sawzall, he loses his balance and is forced to fall off of this unguarded platform. With regards to this section, with regards to the common law negligence claim, there's no proof that this catwalk, which is 6 to 7 feet over the roof, ever had a guardrail from the time that they took over the building up until the time of the accident. So whether they're out of possession at the time, the defect that existed from the time they had leased the property to KFG operating. So that's the question of fact.
Okay. All right. We'll hear from your adversary now, and then you'll have time on rebuttal on your cross appeal. All right.
Thank you, Your Honors. With regard to 240, putting aside everything we spoke about before, this work does not constitute a significant alteration for purposes of the labor law, and there was no repair. The air conditioning unit was not broken. They were sliding in metal slats that required no tools to do the work into preformed brackets.
So are you claiming this was ordinary maintenance, or what are you saying it was? It was some kind of work. What are you saying that it was?
What I'm saying is it's like in Joblon and Bodman, where drilling holes in the building was not an alteration, or chiseling holes in the wall is not an alteration. It's whatever you want to call it, whether it's maintenance.
I'm asking you, what are you calling it?
I would call it, in those cases, they just say it's not an alteration. It's not labor law protected work. They didn't put it in a bucket necessarily of maintenance. It's just not a significant alteration. It's not an alteration of the structure. It's not demolition of the structure. It's not repair of the structure. It's not pointing or painting or cleaning. Just whatever it is, whatever you'd like to classify it as, it doesn't fit into an enumerated activity under the labor law. And if the court has no other questions on any other issues, we'll rest on our brief.
Any questions, colleagues? Okay.
Thank
All right,
you.
we'll hear from Mr. Ilkert again on his rebuttal. Can't hear you. Yeah, unmute yourself. You're not unmuted. Now you're unmuted. Go ahead.
As brief as possible. Mr. Fuller had a co-worker who had to go up with him. They had long panels that had to be cut with a sawzall, traverse up from the roof, up to the roof on this ladder, onto a raised platform, raise these panels in and put them down in order to baffle the sound of the air conditioner, which they had previously been done years before until a contractor had removed them. So the soundproofing, there was no soundproofing. Mr. Fuller and his co-worker are restoring the soundproofing so that they actually work and don't make noise all over the neighborhood.
Right. No, I think we understood that. So what bucket would you put it in? What was it?
Air, because they're changing.
I didn't hear you. Say again. What bucket?
I would put in alteration or repair. Or alteration and repair.
Okay.
Okay, and it's St. V. Syracuse. If you look at the installation of a sign on a billboard, this is much more intensive and more tools. That's all I have, Your Honors.
Okay. Thank you both.
Thank you. Everybody be well.
You too. You as well. Okay, our next case is State of New York versus David.
Good afternoon. Alexandra Keeling with Mental Hygiene Legal Service for David S. this afternoon. May it please the court. Here, the jury instructions were incomplete, and there was a significant possibility that an illegal verdict was rendered where the jury did not know the bright line rule of Donald D.D. that ASPD alone cannot establish a mental abnormality.
There's no question about that rule of law. That's directly from Donald D.D., right?
Correct, Your Honor, and that is precisely why the jury needed to know it. And without the jury knowing that, and significantly, where all four experts agreed, it was the only diagnosis that was not in dispute was ASPD, was that the jury didn't know what the law was on one of the core legal questions that they were tasked with answering. The statute requires...
Let me just refine this a little bit. Had none of the experts testified that the respondent suffered from antisocial personality disorder, the ASPD, then the Donald D.D. issue of law would not have been implicated.
Correct, and so
that's all. So your position, just so we're clear, is that this additional instruction is only required when one or more of the experts is testifying about this particular diagnosis.
That is correct, and that is the rule. And where Donald D.D. is a bright line rule, it therefore flows that it is a bright line rule that the jury needs to know what it cannot do. Here, the jury only had half of the law. The statute requires that a condition, disease, or disorder that predisposes somebody to sexually offend establish a mental abnormality. And the first question on that verdict sheet is there a condition, disease, or disorder? What the jury does here, this goes to the heart of jury trial principles, right? That only the judge can instruct on the law, that the jury must follow that law, but then they are free to accept or reject in whole or in part, which is, enshrined in Article 10 jurisprudence, that it is the fact finder that is to weigh the validity of these diagnoses. And where on this record, ASPD was the only diagnosis that all four experts did agree on, that was undisputed, you can imagine that the jury could say, everybody agreed on ASPD. We don't even need to go further here. And they did not know that bright line rule. And I think it's important that without knowing that, it really actually discourages respondents in these cases from choosing a jury trial. They are forced to choose between a fact finder who knows the law, which would be a bench trial. We know that judges here in the First Department, since this case, have been granting this request, reaching a very simple, direct conclusion that if ASPD is presented, the jury needs to know that it cannot base mental abnormality on that alone. And if we don't tell them that, they won't know, and we have a real risk of an illegal verdict, which again here, where ASPD was the only diagnosis that was undisputed, is a very significant risk that that is what happened. And it impinges upon respondents' rights to a jury trial. They can choose a fact finder that doesn't know this core law. And these cases are complex with all of this complex scientific expert evidence. They have to know what they cannot do. And so here it's not as if a court can say, well, I think there was enough evidence on one element of robbery, so I'm just not going to include that element in my jury charge. This was a core question for the jury. It's jury question number one. And they did not know, they did not have the complete instructions in order to come back with that permissible verdict. They only got half the law. And in fact, what they do here, again, standard jury trial principles, they do here that they are free to accept or reject in whole or in part any of the testimony from the experts. And so what they are hearing is that it would be permissible to base their mental abnormality verdict on ASPD alone, and that without hearing from the judge and that imprimatur of jury instructions Jury instructions precisely are there to provide guidance, to give the jury the tools that they need to come back with the permissible verdict. And this court cannot have confidence in this verdict or in any verdict where ASPD is presented, where the jury doesn't know that about the Donald D.D. bright line rule. It's simple, it's straightforward, and it's for these reasons that we are asking that this court reverse.
Counsel, I have a somewhat secondary level question, which is that if we agree with you about the instruction, are you asking us in addition to say, to make a ruling or to address the issue of the court's refusal to hold a Frye hearing on hypersexuality? And is that something we need to address? Or if we reverse it on the Donald D.D. issue, is that all we have to do?
That's all you have to do, Your Honor, and that's all we are asking you to do today is to reverse on that jury instruction regarding Donald D.D. It would be a new trial and any other issues can be addressed there. So you don't have to reach any other issue but this one. And again, if there are no further questions, again, we would ask that you reverse based on this bright line rule. Thank you.
Thank you. All right, counsel.
May it please the court, Mark Grube for the state of New York. I'll turn straight to the jury instruction issue. The court has discretion to reject a jury instruction, even if accurate, where it's unnecessary in light of the particular evidence and arguments presented at trial. And here the instruction was unnecessary because the state's experts did not rely on ASPD alone. The state never argued that ASPD alone was sufficient to establish a mental abnormality.
Counsel, excuse me, how would the jury know that it could not make a determination if they all agreed, if all of the jurors agreed that defendant had ASPD, but they didn't agree that he had anything else? How were they to know that that was not sufficient for a finding against defendant in this case?
If I could first just step back a sec.
Step back a second. It seems to me under Donald D.D., if they all agreed on ASPD, but all thought he had something else but couldn't agree on what it was, then under Donald D.D., they could not make a finding against defendant, right?
It would be legally insufficient. Under Dennis K.
You know that.
I'm sorry, you were over talking. I didn't.
Sorry. How would they know that that would be legally insufficient?
Because it was not presented as a theory of the case on either side. So requiring to do so would require assuming that the jury discarded both arguments by the state and MHLS. And when there's no indicia of jury confusion, the court should not make that assumption. There's no...
What confuses me about what you just said is it suggests that they would be taking instructions of law from the argument made by you or your co-counsel and by MHLS, and it's a basic principle that the jury should only take principles of law from the judge. So it seems to me that what you just said suggested that they should get these principles of law from the parties, and that's troubling to me. Could you explain that?
No, I'm sorry, that's not our position. Our position is that the content of jury instructions is informed by the background of what arguments have been presented and what evidence has been presented at trial.
And the evidence here was that he suffered from antisocial personality disorder, right? It was the strongest evidence of a diagnosis made. All four experts agreed on it, correct?
All four experts agreed on it. The evidence presented, though, when you look at the entire picture, was that the state, this was a class battle of the experts, the state presented evidence that there was a complete psychological portrait involving ASPD, psychopathy, narcissistic personality disorder, hypersexuality.
I understand, but there was cross-examination on each one of those diagnoses. And so the jury was free to listen to the evidence and say, okay, there's antisocial, the ASPD, but I don't really buy this psychopathy. And how are we to know? How are we to know what they did?
Well, under Dennis K., that's not the jury's task. The jury is not to serve as an armchair forensic examiner, parsing the DSM-5 and looking at what particular diagnoses the respondent suffers from. That would lead to the question of, does the jury...
That's a bit of an overstatement. I mean, the jury has to make a finding of mental abnormality that fits the criteria under the mental health law. And so if you're relying, and Donald D.D. says you have to have diagnoses to otherwise fit that within. You know, you can't just do it in a vacuum. So I have to admit, I'm really having trouble understanding your argument that this is not a significant instruction to tell the jury, at least in those circumstances where any one of the experts is relying at all on a antisocial personality disorder. How do you parse it out?
Well, respectfully, our position is not that the instruction is never appropriate. If there had been testimony,
when would it be appropriate?
Well, sure. If an expert testified, each ASPD is sufficient, or even if the expert testified, any of my diagnoses in isolation are sufficient to establish mental abnormality. But what the state's experts testified,
that's an issue of law. The conclusion of mental abnormality is a conclusion of law. The expert testifies as to diagnoses and can testify whether they're predisposition type diagnoses. Not right. More than that. Again, and I know this is a very difficult subject matter in these kinds of cases, but honestly, I'm actually surprised even that the state didn't join in asking for the instruction. It's an issue of law. It was clearly important in this case, and how would it only would have made the record stronger for everybody.
Well, the point is it was within the court's discretion here, particularly in light of deviating from the pattern jury.
I think that's an unfair statement. The court is charged with giving the jurors the law. That's the court's responsibility. They don't have discretion to just willy-nilly pick things that apply and don't apply. They have to give them an accurate recitation of the necessary law for the jury to make a decision. So I don't think that this is really he could have done it, he didn't have to do it. He had to have an instruction that fairly gave the jury the parameters of the law by which they were to make the decision.
Well, I'll just turn to Dennis K. again, which characterizes this strand of cases. Again, Donald D.D. is just one. There is also Shannon S., which says that a mental abnormality finding does not have to be based on a DSM-5 diagnosis. You have the
that may go to the issue of whether hypersexuality should be considered, but that's a different issue. It's a different issue. I agree with that.
Right. My point,
whether there should have been a Fry hearing, but that's a different issue.
Right. My point is that there is a strand of cases in which this is one isolated part of a line of cases that Dennis K. has characterized as a question of legal sufficiency, and so. The court can dismiss a petition. The court can give a directed verdict. Again, if there's any indication that this issue is sort of teed up by the evidence and arguments of counsel, then an instruction is certainly appropriate. But the argument is that under the facts here, it was not necessary. And I'll also want to emphasize that courts have made considered harmless error analysis in the Adrian S. case. It rejected it, but the courts have engaged in harmless error analysis with respect to Article 10 jury instructions. And again, here, looking at the totality of the experts' testimony, a battle of the experts where David S. argued ASPD only, that's insufficient for mental abnormality, and the state argued the constellation of the 5 different disorders and conditions that I've referenced before, and that those establish a mental abnormality, not by themselves, but by the interaction among the different disorders where the narcissism caused a need for power and control, and the hypersexuality cause those personality disorders to act out in a sexual manner. Given sort of the totality of the circumstances and the way the argument was presented to the jury, to assume that the jury could have found ASPD alone and still found a mental abnormality would require that they rejected the state's evidence, which is not consistent with the posture.
They couldn't
on the jury.
reject it in part and accept it in part. Jurors do all the time. That's a rhetorical. I'm gonna withdraw that question. Let's hear from your adversary. Go ahead, rebuttal.
Your honors have it exactly correct, and to that extent, I will waive rebuttal. It was required here. It's core jury trial principles, and we're asking that you reverse.
Any questions? Okay. Thank you both. Very interesting argument. Thank you.
Thank you, Your Honor.
Yes.
Oh, just thank you.
Okay. I'm going to close court
Thank you.
now. This session of the appellate division is now closed. Have a good evening, everyone.